We have some reviews to do for people who have court orders to comply with. Your name's called, come up to the table to the right. If you don't get called, think you should have, go check in with the clerk to see why you didn't get called. Call the reviews.
Raymond S. Brown, Alicia R. Clay, Jeffrey Collins, Tracy L. Cockrell, Pete Goebel, Brandon F. Miller, Jerry G. Morrison, Robert P. Byers, Jr.
Okay, Robert P. Byers, Jr. Case number 22-2120. He has paid a substantial amount today that may pay it off, it looks like. New life recovery. You guys go ahead and stand up. Completed the sober living program there recently, May 10th. So, community service is done. Looks like you are completed, Mr. Byers. Congratulations, you've done really well.
Thank you.
Good luck to you, sir.
Thank you.
This case is marked completed. Raymond Brown, TRC 21-965. Raymond Brown has not appeared. We'll have a warrant issued for failure to appear. Jeffrey Collins, he's usually, he's on teleconference. And Mr. Collins, you've already paid something on your files today, I see.
Yes, sir.
His 19-1082, 19-304, 15-606. You prefer Mondays, Mr. Collins?
Yes, sir, that's fine.
June 17th will be your next hearing. 9 o'clock.
Thanks, sir.
Thank you. Alicia Clay, 2268. Alicia Clay has not appeared, and she's not finished, so there will be a warrant issue. Tracy Crockwell, 2589. Paid off the fines but hasn't done community service, so it'll be a bench warrant for failure to appear. Pete Goebel, 182906. Hasn't done hardly anything on this case at all, so he hasn't appeared. So
I'm here.
Oh, you're here.
And I have my fine to pay in full. I just didn't get in here in time. They'd already brought the files back. They said.
Okay. You go 685 and you got community service left. So you're paying 685
Yes. And I've done 2 days of community service.
recently, or?
Yes, this past week I did.
Okay, well, that's why I hadn't shown up yet. Okay, so you'll have 3 more days of community service and you're gonna pay your fines off.
Yes, right now.
Okay, I'll set you for June 17th. Also, when you get the rest of it done by then, you don't have to come back.
As far as the 3 days community service go, is there any way I could pay those off? Or
No.
No, okay. Okay.
No. We don't need money that bad.
I understand.
June 17th.
Okay.
You can do it Saturdays, you can even do it on Sunday if you have to make an appointment to go to the dock down to do it on Sunday.
Okay.
Okay?
I'll take care of it, Judge.
June 17th, your next hearing.
Okay. Thank you.
You're welcome. Brandon Miller, 23-184. Brandon Miller is on teleconference. Okay, so you've done some community service since your last hearing. You did May the 11th, and you still have some fines to pay. Do you have a payment on your fines?
I made a $50 online payment this morning.
Okay, well, that's not gonna show up yet. I'll set your next hearing for June 17th. If you did make that, I'm showing your balance still is gonna be pretty healthy, over $800, and you've got 3 days of community service left.
Yes, sir.
Okay, get it finished and quit coming to these hearings. 9 o'clock, June 17th.
Okay, thank you.
Jerry Morrison.
Yeah, right, Your Honor.
Yes, 2453. Okay, very good. Okay, it's a very good report. You've already paid your fines off, so Mr. Gwynn said you were doing great. That's what he told me when he approached the bench, so very good. Good job. Let's set it,
What days do you come in? Tomorrow, okay.
June 21st will be your next hearing, 9 a.m. Good job, keep it up, sir.
Thank you, Your Honor.
You're welcome. Okay, that finishes the reviews. We're going to do arraignments next.
Back down arraignment in the courtroom now.
You have a new case, or you missed a hearing on an old case, you need to be here now, we'll call your name. When your name's called, come up to the table to the right. When your name's called, come up to the table to your right, stand there. I'm going to go over the charge with you. You don't have to say anything. You have a right to remain silent. If you do make statements, though, what you say is on the record. It can be used against you. You have a right to have an attorney. You can have an attorney appointed if you're facing a jailable offense and you qualify financially. I have to ask you about your income before I can appoint a lawyer for you. You have a right to bail. You have a right to make the state prove any charge against you beyond a reasonable doubt. If you enter a guilty or no contest plea, you're waiving those rights that I just explained. And you should not waive your rights if you don't understand what's happening. If you want to talk to a lawyer, if you want to have a trial in your case, any of those reasons, you should enter a not guilty plea. That's always the safest plea to enter. Call the first case.
State of Ohio versus Lyle R. Keeney, case number TRD 24936, A, B, and C.
Answer, you're Lyle Raymond Keeney.
Yes, sir.
Mr. Keeney, it's alleged that at Union Township, May the 10th at 6:21 p.m., you were operating a motor vehicle while you did not have a driver's license. That's a unclassified misdemeanor. Maximum penalty is 500 hours of community service and a $1,000 fine. That you were speeding, driving 71 in a 55 zone. That's a minor misdemeanor. Maximum penalty is $150 fine. And that you were driving a vehicle that had two dark window tint on the windows. That's a minor misdemeanor. Maximum penalty $150 fine. Do you understand these charges?
Yes, Your Honor.
Do you understand your rights?
Yes, sir.
How do you plead to these charges?
No contest.
No contest means you don't want to fight it, and you're agreeing that I can find you guilty if I think the state has enough evidence to convict you.
Well, not guilty.
Okay, I can't appoint a lawyer for you because none of these are jailable offenses, so the most you can get is community service.
Okay.
So,
I'm in the middle of getting, West Virginia has a hold on my license. They want me to put a BAC machine in my car. And so I'm trying to do that. And, yeah, so I can get my license, actually.
okay, well, I can just set this for a trial, and we'll have the trooper come in and testify if that's what's going to happen. Is that what you want me to do?
No?
Well, that is what, if you enter a not guilty plea, that's what happens. I'll have a trial on it.
Then guilty,
Okay, guilty plea means you're admitting the charges are
Right.
true. Do you understand that?
yeah.
Okay. I'll accept your guilty plea. Let me read what the officer says about it, and then if you want to make an explanation, you can. The officer says, I checked the defendant's speed at 71 miles an hour in 55 zone. He had an ID card, not a driver's license, and his window tint blocked 35% of light. Is this your car or somebody else's?
Yes, it's my car.
You do have insurance, so that's good.
Like I said, I'm in the middle of getting that BAC machine put in my car so I can get my license and stuff.
How long is that gonna take?
They're harder to get a hold of than you might think, the BAC machine people.
We know one in Portsmouth. Is that the one you're trying to get in touch with?
It's in West Virginia, actually.
Okay. I don't know if they would accept that in West Virginia, but there's one in Portsmouth. You can ask Mr. Major about it, how to get in touch with him.
Okay.
Well, if you want to try to get that, come back and show me you're doing that, getting your license reinstated, I'll give you less of a penalty.
Oh, yeah, I do want to do that.
Okay. How much time do you think you need to get that done? A month or more?
Yeah, probably about a month. Sounds great.
Okay. I'll set it for more than a month, so let's make it, sometimes these things take longer than you think. I'm going to make it for July 1st. July 1st will be a sentencing hearing,
Okay.
and that's going to be at 10 o'clock on July 1st. So there's a form there in that little basket in front of you for you to put your next hearing date on.
Okay.
July 1st, 10 a.m. You got to come back whether you get your license or not.
I got you.
And I'm going to let you sign a $1,000 signature bond. Do you have any questions, Mr. Keeney?
No, sir.
Okay, that's all. We'll see you on July 1st.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Brian McClellan, case number PRD 182552 A through C, PRD 16200, PRD 16007 A and B, PRD 143549, PRD 101638 A and B.
All right, Mr. McClellan is here. You missed the hearing. You, well, actually, I think it's set for today. You just like getting here?
Yeah,
Okay. So you made a payment today?
yeah, I paid 40 on it.
All right. Next hearing is June 14th.
Okay, thank you.
9 o'clock.
State of Ohio versus Jonathan T. Register, case number PRD 24159 A and B.
All right, this is Mr. Steyer's case. This was set for Friday, I believe.
Yes, sir.
Steyer is not here yet. He had a hearing in Cabot County this morning, but he will be here. He's running late because he's got to go to that hearing first. So just have a seat.
All right.
Recall that when Mr. Steyer gets here.
Thank you, sir.
Do I need to get that one?
Yeah.
They say register.
Okay. Okay, we have some pre-trials now. We'll start.
State of Ohio versus Cody Hatton, case number TRC 24538, A and B. Mr. Holt's case.
Cody Hatton?
Do we have pressure on it?
Yes. All right, there's still discovery ongoing in this case. There's been an agreement to continue it to June 17th at the defendant's request at 10 o'clock.
Thank you, Your Honor.
Next pre-trial, June 17th, 10 o'clock.
State of Ohio versus Robert Gilbert, case number CRB 23567, A and B. Robert Gilbert.
You know, we were here just on cost. This is about the 5th time I think we've been here on cost. I don't know if they've been paid or not.
He has not. And he's not appeared, so he's got 7 days to come in for more questions.
State of Ohio versus Heidi R. Taylor, case number CRB 2485.
Mr. Dwyer's case set for pre-trial.
Your Honor, I've talked to Mr. Hill about this case. I believe Ms. Taylor wants to change her plea to guilty to this charge.
Is that correct, Ms. Taylor?
Yeah, I think it's right.
Yes.
No, and this is on a theft offense. All right, Ms. Taylor, I'm going to ask you to go submit to a urine screen, and then after we get the results of that, I'll do the sentence. So,
Thank you, Your Honor.
State of Ohio versus Brittany Sykes, case number CRB 24187.
Your Honor, she is on her way right now.
all right, so recall as it is before 10.
State of Ohio versus Samantha Cooper, case number CRB 2472.
Mr. Thompson's case set for pre-trial.
She hasn't checked in yet, Your Honor. Can we recall it?
Recall.
Please.
State of Ohio versus Tyus Ferguson, case number TRD 24641, and PRC 23506, A and B.
Well, honestly, I really have no
Mr.
concern.
Ferguson, do you have a lawyer?
Yep.
Mr. Thompson,
Oh, Mr. Thompson, okay.
consider what other sanctions that the court might impose. Your Honor, we've had a discussion about the situation here involving the allegation that Mr. Ferguson was driving under an active ODI suspension, and our records indicate that he was. Looks as if the suspension came out of Boyd County, Kentucky.
Okay.
And-
Well, there was an OVI in this court in August of '23. August, this site, the entry went on August 25th of 2023. So I don't know if that may be outside the 6 months. I'm not sure when the, pull it up.
Looks like it was 5/7/23 is when that was filed here.
Conviction looks like it was 8/25/23.
We need 23/506, is that what you got?
Yeah. 8/25/23 when they did the sentencing. And
Okay.
the violation date was 5/7/23.
Our records indicate that the suspension on that case expired on February 25th, 2023.
Yeah, that date on there is wrong.
Up here at the top.
In the, that can't be right.
Oh, there's the Kentucky case.
Oh, that's from the OBI suspension.
Yeah.
On the 506, that should be, it's, yeah, that should have been 180 days.
What do we have it down?
Well, there's not 180 days. I mean, in the judgment entry, it says that it's the written one. It says 3 years to be reduced to 90 days to successfully complete an approved treatment program. Okay, I think what happened was it got modified because he had failed to appear. Yeah, there was a 3-year license suspension put on because of the failure to appear at one point. And that's still in the entry, So as of the time he got this driving under suspension, he was still under the OVI suspension. So how's the state going to proceed?
We had a conversation with Mr. Thompson about the fact that if there's an active OVI suspension and the defendant is found guilty of driving under that suspension, that it's a mandatory 3 days in jail. We didn't discuss any other possible sanctions. The one that we did discuss was the mandatory jail time.
Okay, and I'm looking at the report from that citation and arrest on the driving under an OVI suspension. In the write-up, the officer said he had a felony warrant. So what happened with that?
What?
I don't know if that was incorrect. The officer says the defendant was traveling US 52, made a lane violation, stopped, stated he did not have a license that was valid, checked his license through leads, it came back suspended, and that he had a felony warrant. So that's what I'm asking if
You said it was a warrant for her failure to appear.
in the common police court or this court?
This court.
Do you know anything about there being a felony warrant?
No, we don't have any information about that, Your Honor.
Okay, so Mr. Thompson, how do you want to proceed?
Well, based on the discussions we had with the prosecution, we would change our plea to guilty.
Okay, is that correct, Mr. Ferguson?
Yep.
Well, what I want to do before I sentence him, can we check to make sure there is not an active warrant out of felony court. So, just have a seat, we'll recall once we get that information, and then I'll sentence you once I get the confirmation. So whether there is a warrant or not.
State of Ohio versus Heidi R. Taylor on a recall, case number CRB 2485.
Judge, after speaking with the folks that administered the drug test, it's my understanding Heidi didn't have any illicit substances, except for she did have her prescription medicine showed up, but she did test positive for alcohol. She indicates to me she doesn't drink that often, but she did have a couple of drinks for Mother's Day yesterday.
Does she have a prescription for the amphetamine?
Yes.
Do you have that with you?
No, I don't think, I didn't tell her to bring her prescriptions with her.
Okay, I want to see the prescription, or I'm going to make you go get an assessment.
Okay. I mean,
Can you bring it in?
I can, yes.
Okay, do you have it where you can get it today, or do you want to come back for another hearing?
I can bring it back in later today. I have to go home and get it.
How far away is that?
Out in Willowwood.
Well, we probably just need to reschedule it unless Mr. Daughter wants to hang out here while you drive to Woodwood and back.
Can I just go to, my doctor's in Huntington, can I just go over there and get a copy of it? Or like a paper? Or?
Do you have it on your phone?
No, CVS.
Judge, I've got a jail case that'll get caught up in a little bit, and I've also got a sentencing. Let me work with her and see if we can get it here, and if we can, that'll be fine.
We'll call it and then decide if we want to do it today or
Okay.
another day.
All right, thank you.
State of Ohio recalls Jonathan T. Register, case number CRB 24159 A and B. Understand Mr. Steyer.
All right, this is Jonathan Register. It's set for, well, it's set for pretrial Friday, so he's in here today.
Hey, okay,
He has a bond up with Mr. Sowers.
Walmart. And, and for paraphernalia.
okay. Your Honor, the state has gotten the video on this. I need to get that video and take a look at it, so I'd like to ask that the warrant be withdrawn and that we reset this matter on an upcoming date that the court deems appropriate.
Does he have an explanation for missing Friday?
It had been rescheduled and I just wasn't aware of the date, and I was at a job interview and when it all went down, and I just...
Yes, Your Honor. You may recall that we had a previous occasion where he had he had a doctor's excuse on a previous occasion. On that date, we rescheduled. I can't find that I ever actually got back a hold of him. He got a hold of me on Friday and said, "Hey, I've got this job interview issue," and I said, "Well, I'll see what I can do, but I'm going to continue." I think his non-appearance Friday was actually my fault, Your Honor.
All right, I'll cancel the bond forfeiture hearing I set for June 14th. I just texted Mr. Sowers to let him know that he did appear at the defendant's request. We'll continue this to another hearing date, and probably looking in June. We are looking in June.
Would the 10th work, Your Honor?
Yes.
Actually, is Monday or Friday better for you? Does it matter?
Either day.
Okay, then the 10th, Your Honor, please.
June 10th will be the next hearing. Pre-trial, 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Caitlin M. Bryan, case number CRB 23731. Caitlin Bryan.
This is also Mr. Steyer's case. This was a case that, and it's going to be dismissed as the costs are paid. The costs are paid.
Yes. Little victories, Judge.
Yes. Case will be dismissed.
Thank you.
State of Ohio versus Dana Howard, case number CRB 24235.
There's also Mr. Stiers' case set for pretrial.
Just a moment.
That was my understanding. That's what I wanted to bring it back. We brought it back that day. Oh, okay.
Your Honor, this matter is one we brought back here from a previous filing. At this time, what we have is an M1 domestic violence.
This is one that went to the grand jury and came back.
Well, it didn't actually go to the grand jury. It was nollied or waived on, and then we caught it before it was actually presented and brought it back.
Okay.
And at this time, Mr. Howard is willing to enter a guilty plea to the pending charge here, which is an M1 domestic violence.
Is that correct, Mr. Howard?
Yes, sir.
What's the state's recommendation?
The state's recommendation, and I would like just for a moment to speak with Ms. Boyd. Okay.
And if I may, Your Honor, what's the case number we have today?
This is 24-235.
Thank you.
Your Honor, the state's recommendation, and speaking with Ms. Boyd about this, would be 60 days in jail suspended, and of course, we're going to ask for no contact order. And she also says that Mr. Howard still has a key to her residence, which she wants back. So hopefully, he has it.
Do you have that with
right
you by any
now.
chance? He doesn't have it with him, but we can, could he drop that off here and she could pick it up from the victim's advocate, or I guess it probably wouldn't be victim's advocate most days, but the office over there.
How far away does he live?
Where do you live?
About 10 minutes away.
Is that where the
I'd like to
the
get
key is?
That
Yeah,
would
but
really
I don't
help
have
to-
any transportation today. I had to get a ride here and stuff. I don't have no way.
He doesn't have anywhere to get back here after he goes home. Can you get here on another court? If you can get here on another, can you come here Friday, do you think, and bring the key?
Yes.
I'll be here Friday. Come here about 10 o'clock.
Okay.
Can we delay sentencing to
Yes.
Friday?
Okay.
All right, so I'll just put this on the docket for this Friday, the 17th, for sentencing, and we're looking for a house key then.
You want to be here Friday, you can be, okay?
Okay.
Go back Friday.
Friday.
It's not, let me go ahead and ask Ms. Bowyer, it's not required that you be here Friday. Is there anything you want to tell me so I'll know it when I sentence him on
No,
Friday?
I just want the key back to my apartment and stay away. And I need someone to come and get his clothes and stuff out of my apartment.
Well, is there somebody that is a go? What about the gentleman behind you? Is it okay if he comes and gets them?
Yeah,
And he could give me the key to the place to give to her, if that would be allowed.
Either way, just as long as it's gotten to her by Friday.
Okay.
I can make arrangements to meet up with him later on today and get the key.
All right, so we'll still do the sentencing on Friday, and hopefully by then, his stuff and the key will be swapped.
Okay.
Anything else that needs to happen?
Nothing at this time, Your Honor.
Okay. You set for Friday at 10 o'clock for sentencing.
Thank you.
Thank you.
All right, thank you.
State of Ohio versus Micah Ross, case number TRC 213080, A and B.
Jeremy Kern.
Sorry. I bumped into you.
Mr. Stiers' case, Ms. Ross is at the podium.
May I approach him?
Yes. Yes, you may.
Ms. Ross is about 20-some days out from transitioning to sober living, where she'll continue to get her feet stable. She's done excellent in the program. I mean, I don't have anything but good things to say about her.
Okay, very good, good report. Okay, continue then until she completes. Is that agreeable?
Yes, Your Honor. Said about 20 days, so if we were to come back, also, the 10th is sometime a little bit past 20 days, we should know our status at that point.
Okay. June 10th will be the next hearing for sentencing. Hopefully by then she'll be completed.
Thank you, Your Honor.
Good job.
Congratulations.
State of Ohio versus Howard Thornton, case number TRC 24-530, A, B, and C.
You have just a moment to speak to Mr. Hill.
Set for pre-trial today.
Now, that's
Yes.
Oh, okay. Oh, okay, sorry.
District, I can see that. Ironton.
Well, it's usually
It's a good report from Mr. Thornton. Good job, sir.
This is one of the ones where it doesn't actually find. Okay. Well, plus refusal and an additional 120, so he does.
Well, that doesn't change the count. That changes the minimum sentence under the count.
I know.
So,
My question is, what are we gonna do?
First offense.
How about let's have him plead and do his counseling and then consider saying something like that?
Something from him.
No, it's not. Always.
It isn't, it's not that we have to put it without it.
Okay, well, that's exactly what it is.
Just, I'm not saying it's a job.
I know that. Here's a 17, this is legit. Okay, here's a 14 Ironton. Oh, you're saying
That doesn't fly.
Approach, Your Honor.
Yeah. All right, there's a legal issue as to whether this would be treated as a second or third, and as I understand from the bench conference, the state's okay with, if Mr. Thornton continues on the path that he's on, does really well in treatment, they'll recommend that it be treated as a second offense for purposes of sentencing down the road. So we got that commitment from the state. What I want to see Mr. Thornton do is continue in treatment as he has been. He's been getting really good reports, and if he continues on that path, then the state's going to recommend to the court we treat it as a second offense and not a third offense, and that is what Mr. Sire.
It is, Your Honor.
So let's come back in another month, roughly, and see how Mr. Thornton's doing then.
Is there going to be a plea today to the OVI delay sentence?
I think we're going to just continue the matters of pretrial at this time.
I'm fine with that, if you want. It's not my understanding that the defendant wants to contest this. I mean, if he's saying, I'm not going to...
I don't anticipate contesting the underlying case itself anyway.
So just for clarity's sake, we want to encourage Mr. Thornton to continue in his treatment, and he's got a good start. The discussion we had at the bench had to do with what offense level it actually
If there is a plea, if there's going to be a trial, I understand all bets are off.
Well, I'm not even sure about that, because I think that Mr. Steyer has a case about one of the prior Ironton Municipal cases and the judgment entry. We've been through that before, and I believe he may be right about that. So what I'm saying is that we would believe that it's a second offense if it was contested. But we also want him to be encouraged to do his treatment and not get back in this situation again, because at least the preliminary breath test was very high. So we have concerns about his well-being. So what we would like him to do is go ahead and plead guilty today with the understanding that he's got to do well in his treatment to get any consideration from the state as far as what our final recommendation is going to be. In other words, we consider it a second offense now. If he pleads guilty now and does well in treatment, then we believe that, you know, it's worth some consideration down the road. If that makes sense.
If that's what the court's preference is, we can go ahead and enter a plea today. That'd be fine, Your Honor.
All right, is that what you want to do, Mr. Thornton?
Yes, sir.
All right, I'll accept your plea. I'll delay the sentencing, and so we'll come back June 17th.
Your Honor, I'm out of town June 17th.
Okay, when are you available around that?
Hang on just 1 second, let me. I'm here the 14th and the 28th and the 10th.
Let's do the 28th.
Okay.
June 28th, it'll be a sentencing. Continue in your treatment as you have been, Mr. Thornton.
Yes, sir. Sure will. Thank you.
You're welcome.
Good job.
Thank you, Your Honor.
Thank you.
State of Ohio versus Aaron E. Wenzel, case number CRB 2427. Aaron Wenzel.
Aaron Winslow, Mr. Stiers' case is set for pre-trial. I think he was at RRS.
He was, and he left against staff advice, Your Honor.
And Your Honor, Mr. Wenzel actually contacted me late last night, stated that he had a work situation, that he had to work basically 2 shifts together, and asked for continuance. I told him at that time I'd seek a continuance. There's a decent chance I could get it, but that was before I was aware that he wasn't going to get the best report in the world. So I'm going to go ahead and make my motion to continue this matter, and then the state can respond as they see fit.
What's the state's position?
Well, given the fact that he's left treatment, we have some concerns about that, and maybe that he's using again right now. I guess we just need to ask for a bench warrant to issue.
He's got 7 days to get in here before warrant will actually.
I'll speak to him, Your Honor. Thank you.
You're welcome.
Thank you, Your Honor.
Thank you.
State of Ohio versus Ryan J. Plants, case number TRD 231541 A and B, CRA 19718.
All right, Ryan Plants, this is Mr. Smith's case, Mr. Norford standing in. Ryan Plants.
Your Honor, Mr. Plant successfully completed the Bethesda's residential program.
Okay, good, very good. You have a written report for that?
I will get you one.
Okay. So this, we've got an old case, 19 case.
Yes.
Is a possession. He's been there since October?
Yes.
Okay. What's the plan now, Mr. Plant?
Currently staying with my parents and trying to get on the borges.
Trying to get what?
On the borges.
Oh, okay, get a job. Yeah. Have you done that before?
No, sir.
Is there, is there aftercare plan? What's the aftercare?
The aftercare, well, with the barge situation, we would just ask that he would reach out to us afterwards so we could set up some type of outpatient.
Are you doing anything now? When did he finish the inpatient?
He finished a month ago. He should have been signed up for outpatient. I apologize, I don't know why he was not.
Okay. I'd like for him to do a urine screen today. Just have him do a urine screen and then come back and see. Then in the intervening time, maybe you can talk about getting a aftercare plan.
Absolutely.
Okay, we'll recall this.
Thank you, Judge.
State of Ohio versus Kimberly Hass, case number CRA 2364, CRB 2365, A and B.
All right, this is also, Mr. Morford, I think it's your case. All right, 2364, 365. This is a pretrial on review.
I think it's.
I think I'm Mr. Smith also.
Okay, you're still with Mr. Smith. This is
Yes, I believe we had two cases before you this morning, Your Honor.
May I approach, Your Honor?
Yes.
Ms. Hass is still in residential treatment. She's done exceptionally well. Stayed put, which was a good sign, and she's doing everything she's supposed to be doing.
Okay, very good.
Your Honor, do I have community service also required? Because I'd like to start completing it if I do have it.
You do not, but you can work your fine. You have some fines. You can
I
work
think
these
they
services.
have been paid.
It looks like you're right.
Yes.
They have been paid.
Yeah.
Okay, so this is all you got left to do is get punished.
All right.
Okay.
All right. Thank you, sir.
Looks like you're on your way.
Yes, sir.
Doing well. Okay, I'll set you for June 28th as your next hearing.
Thank you.
Thank you,
Good
Your
job.
Honor.
Keep it up.
Thank you, Judge.
State of Ohio versus Travis L. Black, case number CRB 23743.
This is Mr. Morford's case. Mr. Black, was it Bethesda?
He was transported to behavioral health, Mountain State Behavioral Health, and he's been there ever since.
Okay. Where is that located?
I think it's up there by Athens, maybe.
Oh, okay.
Appalachian Behavioral Health.
Appalachian, not why I said mountain, but.
Okay, yes, now I remember. Yes, he's,
We called that into question, Judge, I believe,
yes.
early on.
All right. I have not gotten any reports back from them to what's going on. Looks like he's been there a little over a month.
Yes.
Judge, I'll see if I can't make that happen this morning.
Okay. I'm just gonna go ahead and set another hearing. Let's make it not so far out.
I'm waiting for him.
I also have an email to the lady that did his intake, so I'll reach out to her and see if like they know what's kind of going on.
Okay. June 7th? June 7th will be the next hearing.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
State of Ohio versus Brittany Eplin, case number CRV 23589, A and B.
Mr. Worker's case set for pre-trial. And we set this because she switched to hometown here recently. Yes.
Clarence?
I think that would be answered by this lady here. They're the ones that give you the pass. She's looking up, she would call.
Okay, well, it's not a good report.
They're the ones that say
Two words that are bad in this report, uncooperative and manipulative. So, sounds like you're still not where you need to be on treatment. What do you have to say?
I've been doing good, that's what I thought. I'm doing good.
Well, that's not, this was signed by Samantha Workman. Do you know Samantha? Says she's CDCA. I don't know, do you have a counselor there that you work with? She claims, I guess you call your mother, which you're allowed to do, then have her place calls to people that you're not supposed to be in touch with. So you can evade the rules.
No, sir.
Okay, are you still willing to keep her?
We're still willing to keep her.
Okay, well, let's come back the next time and get a better report, okay? Maybe this was a mistake. So if it was a mistake, it won't happen this next time, all right?
Yes, sir.
Okay. Mr. Hill.
Well, Your Honor, Mr. Ellswick, the alleged victim, was here, and I wanted to make sure what his feelings were at this point. And-
Okay, let's have him see.
Well, yeah, he's still here.
You want to come out?
We want to make sure that she takes this seriously, that's number one. And we've never made any promises as to how we were going to resolve this because of the fact that, we consider it serious anytime something like this comes before the court, and we want her to succeed in this. And I think that Mr. Ellswick would agree that that's our primary concern.
Yeah, because her boyfriend, when she went on the pass, she failed a drug test.
Right, I remember that.
So that's one of the issues I got, So I don't want to see nothing happen to her when she goes on pass.
But she hasn't been out on pass.
She hasn't been out on a pass. I had got word today that the person that she was trying to get in touch with was the boyfriend also constantly, so we've limited.
No,
So, privileges and.
I have not been in touch with my boyfriend.
Okay. Well, let's, why don't we do a urine screen today to make sure we're on track of where we need to be. So we're going to do a urine screen and come back and we'll go from there.
Thank you, Your Honor.
Thank you.
State of Ohio versus Tanya M. Harding, case number 24206.
This is Mr. Morgan's case at pre-trial. Tanya Harding. Okay, this looks like, I think the first pre-trial.
Yes, Your Honor.
Is Natasha Clark here, please?
Or who was it?
Natasha Clark.
Clark.
Natasha Clark? Natasha Clark. No answer, Your Honor.
We'll try to get her subpoenaed for the next hearing. Yeah.
June 10th.
June 10th.
I'm good with that.
June 10th will be the next hearing.
At 10?
Yes, ma'am.
Okay, thank you.
State of Ohio versus Kathy Knight, case number CRB 24147, and
Mr. Morgan's case is signed that because
This is your copy of.
May I approach, Your Honor?
Yes, that's your case. How are you doing? How do you feel about it? How do you feel about it? You good?
Okay, it's a good report from Ms. Knight. June 10th, next hearing.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
Your Honor, ready to go to Lawrence County Jail.
Okay, we have some hearings to do by teleconference at the jail. We'll go there now.
State of Ohio versus William Baker, case number CRA 24283.
This is an extradition matter. Sir, are you?
Hey, Butch.
William Baker, the, there's a couple on there. Sir, are you William Baker? Mr. Baker, I'm Judge Caffer at the Lawrence County Municipal Court, which is in Chesapeake, Ohio. You're appearing in the court by teleconference on a screen in the courtroom, and what you say and your image is all being recorded. You have a right to remain silent. You don't have to say anything, but if you do make statements, they can be used against you, and they are being recorded. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, make the state prove any charge against you beyond a reasonable doubt. Do you understand those things? It's alleged that there's a warrant for your arrest out of a different jurisdiction, Lawrence County, Kentucky District Court, on a burglary offense, which is a third-degree felony in Kentucky. Kentucky's asking that you be extradited, which means sent to Kentucky to face these charges. You have a right to have a hearing in this court on extradition. You can have an attorney. You can have one appointed if you can't afford one. And the extradition hearing will be about whether there's good cause to send you to Kentucky, not whether you did or didn't do the burglary in Kentucky. You understand these proceedings, sir?
Yes, sir.
Do you wish to have an extradition hearing or have an attorney here represent you in that extradition, or do you wish to agree to go back or go to Kentucky on these charges?
I agree to go to Kentucky, sir.
Okay. Okay, so what I'm going to do, I've read a little bit about the charge. This has something to do with Three River Medical Center in Lawrence County, Kentucky. I'm going to set bond at $10,000, cash or surety, so you could use a bail bondsman, probably 10% to a bail bondsman. If you got $10,000, you can post the whole thing. As long as you go turn yourself in Kentucky, you get the whole $10,000 back. Do you want to try to post bond, or do you want to order the Kentucky authorities to come get you and give them a period of time in which they have to do that?
I wish to post bond.
Okay, do you think you could post a $10,000 bond?
I could probably do a bondsman or a
Yeah,
bond.
so $1,000 would get you out with a bail bondsman, usually.
Okay.
So we can have a bail bondsman contact you there at the jail to talk about, is that what you want to do?
Yes, sir.
Why don't we do this? Let's have that happen and see if you can post the bond. And then I'll call you back up after you talk to the bail bondsman to finalize things. If you can't post bond, then maybe the smartest thing to do would be just to waive it and go ahead and go to Kentucky. You don't sit there in the jail. So we'll contact the person who posts most of the bonds here in our county is Mr. Sowards. We can call him. Now, the only thing I know he texted me this morning, he's in Williamson, West Virginia.
I'll text him and maybe I want to do something.
Okay. Somebody from his office will contact you here in the next hour or so, and then I'll have you back on teleconference to decide how we're going to go forward if you think you can post bond.
Okay, thank you.
Okay, so I'll see you back on the screen in a little while.
Thank you, sir.
Letting Mr. Sowards know.
State of Ohio versus Ryan K. Edwards, case number CRA 24232, and Austin Hawthorne is on deck.
This is Mr. Morford's case, and it's on the docket today as a preliminary hearing. And we were waiting to see over the weekend if some things came to fruition about Mr. Edwards' case.
Nothing exceptional, Your Honor, that would, I think that the facts of both of the matters that the alleged victim kind of let us know without being too definite about exactly what the differences were between the report and what actually happened, but something still happened. But if Mr. Edwards, if the court agreed that he should maybe be able to go to treatment the same as Ms. Ham, then we don't have an opposition to doing that. I think we need to have a discussion about a GPS monitor maybe too.
So are you saying the case would stay in this court with treatment, or it would still go on to the common police court with treatment?
At this point in time, we're okay with leaving it here and probably would stay here. And we're not saying that nothing at all happened, just maybe not a second-degree felony.
Okay. Mr. Edwards, are you comfortable with what you've heard, or you want to talk to Mr. Morford about before you decide how you want to go forward?
I've talked to Tyler Davis. I'm on the court docket for Wednesday in Ballard's court, so if he's okay with that, that's cool, yeah.
Your Honor, he was up until he went MIA, he was at Sober Living because he came from Star, straight to Sober Living, and then he stated he had a job, and we just never, we noticed that he wasn't coming, we couldn't, so we reported that he was ASA, but we're willing to take him into residential if I can get common police to agree to it.
So they've got a hold of him also?
Yeah, Tyler Davis is the common police court probation officer.
Okay.
Carl Bell's office.
Well, why don't we do this? Why don't I set an OR bond so not to interfere with what common police wants to do? So if they want to send you to treatment Wednesday, they can do it, and this charge won't hold you up from going. And then just put it back on the docket for Friday, then we'll know then what common police is going to do. So do you understand that, Mr. Edwards? I'm going to give you an OR bond, so if Judge Ballard says, yeah, he can go to treatment. You'll be able to go then on Wednesday because my holder will be lifted because you'll have an OR bond. Then we'll come back Friday, see what the common police judge did, and I mean, if he sends you to treatment, I'll go along with that. Just kind of try.
Okay.
And you could already be in treatment then on Friday.
All right.
So I'll put it on my docket for the 17th. I'll change it from a 5,000 cash security bond to a 5,000 OR bond. Next hearing, so if you get in treatment, just make sure you tell your provider. Of course, Bethesda knows it. If you go there, they know you have to be here, but if it's another provider, let them know you got a hearing in this court on Friday at 10 o'clock.
All right.
Any questions, sir?
No.
Okay, that's all.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio versus Austin P. Hawthorne, case number CRB 2357, CRB 2358, CRB 2843, PRC 191305 A and B, CRB 19393. And Kyle Hopkins is on deck.
All right, Mr. Morford, I think this was actually your case.
I believe so, Judge.
Missed a hearing January 22nd, according to my records, and have been a warrant outstanding since then. He was at the counseling center before then, I believe. I'm assuming you've not had any chance to talk with him.
I have not, Judge.
All right, Mr. Hawthorne, I'm going to let you speak with Mr. Morford, and then we'll have you back after that's happened.
That sounds good.
And would you like the court's file?
Absolutely, Judge. Thank you.
Yeah.
Thank you, Judge.
State of Ohio versus Kyle W. Hopkins, case number CRA 24245. And Heather Robinson is on deck.
Kyle Hopkins is Mr. Morford's case. It's on Rule 4. Okay, so Mr. Hopkins, looks like you weren't still obviously able to post bond.
No, sir, it's just the Thompson came down here and he told me that next had a order on me, wouldn't let me go. And I tried to explain to her that you gave me the chance to post bond and go over for myself in. Sir, I promise, I'll wait for myself in. What's the area number? I'm going to come just again, as near as they go, I don't know. But I promise I'll never take, I'll wait for myself in, the order.
Well, I'm not going to let
She's
you.
got 2 or 3 times to come down here and go down. She did, we brought 1,500 cash down here in her hand. It's not over that they did. Because they told her that I had.
If she brought $1,500 to the court and posted it, I would give you a release, but she hasn't done that.
Not to your court, sir. She came to the jail and they told her that Max has a holder on me. And that they, even if you didn't pay that, we wouldn't let it go because of that. And I tried to explain to her that him that he gave me the order or the phone help to go first from herself. And they said it wasn't in, like, the comments on my paperwork or whatever. I don't know, it's all messed up.
Okay, here's what I think we need to do then. I'm going to let you talk to your lawyer. We'll come back. I'd set a $1,500 cash security bond, so she could come here, post $1,500, or she could get a bail bondsman and give them whatever they charge for the $1,500. They post something. I mean, there's a way to get this done. It just hasn't happened, so. Oh, he won't post his bond, okay. All right, well, there's other bondsmen out there if he wants to talk to them, or he could just say, I'm gonna stay here till Megs comes and gets me. He's been in jail now since May 3rd, it looks like. Yeah. Okay, do you wanna talk with him and you have your file? I do. Okay, we'll recall after you talk to your lawyer. We'll recall you after you talk to your lawyer about this.
I'm going to call you, sir, in just a minute.
State of Ohio versus Heather Ann Robinson, case number CRB 24-281, A and B. William Spalding is on deck.
Ma'am, are you Heather Robinson?
Yes.
Ms. Robinson, I'm Judge Capper at the Orange County Municipal Court of Chesapeake. You are appearing in court by television or teleconference on a television monitor that's in the courtroom. Your image and what you say is all being recorded. You don't have to say anything. If you choose to make statements, what you say is on the record. It can be used against you later. You admit something about your case. You have the right to remain silent. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove the charge against you beyond a reasonable doubt. Do you understand those things?
Yes.
You're charged with a theft offense. It's alleged on May the 11th of 2024 in Fayette Township at the Walmart. You tried to deprive them of property without their consent. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. The B case alleges that you resisted arrest by force. You recklessly resisted or interfered with the lawful arrest of yourself. That's a second-degree misdemeanor. Maximum penalty 90 days in jail, $750 fine. Do you understand those two charges? Do you understand the rights you have as a defendant? How do you plead to these charges?
Not guilty to the resisting.
What about theft?
Guilty to theft.
Okay, do you want a lawyer to represent you on the resisting? Do you have a job?
I do not work with them. Well, I do, but it's like under the table. So I work with my mother.
Okay, how much does she pay you a week?
I make $50 per house, so it depends on how many houses you have. Typically like 300 maybe a week.
Okay, you're eligible for court-appointed counsel. I'll appoint Mr. Thompson to represent you. He's here and has heard your arraignment. I'm entering a not guilty for, I would assume you went not guilty on everything.
Yes, sir.
And I've got an address of Minford, Ohio for you, ma'am.
No, they have my address completely wrong.
What is your current
It's
address?
424 Walnut Grove, Milford, Ohio.
We'd move to amend that, Your Honor.
Okay, Milford, not Minford. Where's Milford? What county is that in?
Claremont County.
What's the state's position on bond?
So she's not guilty on everything now, is that
Yes.
correct? We'd ask for a $2,500 cash or surety bond.
I'll set bond at $2,500 cash or surety. Is that a bond you think you can post?
I'm not sure if I'd be able to come up with that.
Okay. Well, we probably need to set it pretty quick then, if you're gonna not be able to post bond. Next Monday, the 20th. I'll set your next hearing for May 20th. So 1 week from today, it'll be a pre-trial at 10 o'clock.
Okay, but what if I come up with a bond and still get out, right? If I can get a hold of some people?
Yeah. You can
Okay.
get out with, as long as you post bond. The way this works, you can use a bail bondsman, you gotta pay them whatever fee they want, and then they're on the hook for $2,500. Or if you got $2,500, you can pay all that to the court, and as long as you show up, you get it all back at the end of the case, if you've shown up for your hearings.
Okay.
All right, so, do you have a cell? How could your attorney get in touch with you, ma'am?
What is it?
If you're out of custody, how can you be reached? Do you have
My cell phone.
you want to give that to your lawyer? He's here listening.
Yes. 513-289-3001.
Thank you.
Okay, next hearing at 10 o'clock in the court in Chesapeake. So that's about 20 miles from where you are right now, east.
State of Ohio versus William Spalding, case number CRB 23-512, CRB 23-697. William Baker is on deck.
This is Mr. Steyer's case. And it's alleged Mr. Spalding missed a hearing on April 26th.
Yes.
Have you had a chance to talk with him?
No, I haven't. I believe he was out of town that day. He had contacted me previous to that and told me that he was in Florida. That day appeared and told me, let the court know that, but he had missed court previously, so the court issued a warrant. How long has he been in custody? Can you give me just a second to speak to Mr. Field?
Yes.
I think Mr. Hill might have an offer to make.
If he's been in jail for 3 days, Your Honor, we would offer, if he pled guilty to the charges, that the 3 days would serve as the, on the, I guess for both of them.
It's a Walmart shoplifting and a driving under suspension. And as far as I'm aware, he hadn't got his license back. He was having a lot of issues getting there, so.
So we'd ask for like a 10-day jail sentence with 7 suspended and credit for the 3, and we wouldn't take any other positions on fines or anything else.
But as far as we're aware, that would result, if the court were to approve that, that would result in his release today, assuming I have something else holding him. So, do you understand that, sir? The offer would be, if you plead guilty, you'll be getting 10 days in, you would, and the court approves it, that you would get 10 days in jail, credit for the 3 you've served, and that's all that the state's asking for. The court might ask for a fine, and you would also have to pay court costs, and you'd be put on probation for a while, but you'd be done with court for now. Is that something you'd be interested in?
Commissioner, listen, if I can get a warrant on the day, then if I get one of the court days, I would have my license and I would have to show up in a
I'm gonna ask then to have this recalled so I can call him at the jail.
Okay, Mr. Steyer's going to call down and talk to you about this off the record, or
Yes.
at least only the sheriff will be listening.
Right.
Everybody in the room.
I'm gonna get your case called again later. I'm gonna call you. If I could ask that the jailer keep him out for the moment.
You want the court's?
It wouldn't hurt anything. Thank you.
Just let the bailiff know when you're ready.
And just so that everybody knows, we'd be okay if just resolving the theft charge that way today, continuing the DUS charge, and if he got his license reinstated, then we could reconsider what that disposition should be.
Okay.
State of Ohio versus Joshua Turner at Lawrence County Jail, case number CRA 24-238. William Baker will be on deck.
Mr. Delar, are you going to be representing Mr. Turner?
Yes, I believe so, Your Honor. For today's purposes, I am representing Mr. Turner. I spoke with his wife, who's also here in the courtroom today. We intended on having him appear here, but police got to him before he...
Have you seen the charges?
I have seen the charges. I've also been informed that Children's Services did an extensive investigation in this case and found the claims to be unsubstantiated. So Mr. Turner didn't know these charges existed. He thought it was over with, but apparently the criminal charges still got filed. He learned about them and contacted my office. He was supposed, like I said, he was supposed to meet me up here today, but
So is the
couldn't do
mother
that.
of this child present?
She's here.
Okay. And you've been in touch with her?
Yes.
Yes.
Mr. Hill?
Well, Mr. DeLauder has given him more information than I'm aware of. What we would like to do is to verify with Children's Services that they've investigated Are you saying that they found this to be unfounded?
Yes, that's what my information is, and the Children's Services worker's name was Corey.
Griffin.
So could we recall this?
Okay, I'm going to let the prosecutor call Children's Services, verify those things, and then Mr. Turner, I'll have you back later to complete this as to how we're going to proceed. So this case will be recalled.
State of Ohio recalls William Baker of the Lawrence County Jail, case number CRA 24280.
All right, so Mr. Baker, you have talked to Mr. Sowers, and he is going to post your bond. So what I'm going to do, this is Lawrence County, Kentucky. So I'm going to give you a week to turn yourself in.
I've sent a message to her. Did all this come
So I've set your bond at $10,000, and it's my understanding you're going to post that with Mr. Sowers. So I'm going to order you released. I'm also ordering that you appear in Lawrence County, Kentucky before next Monday, May 20th at 10 a.m. Because if you haven't appeared there, then you have to appear in this court May 20th at 10 a.m. Explain why you didn't go to Lawrence County and turn yourself in. So what I want to see happen is that your warrant gets withdrawn within the next week. And you can do that by showing up down there. They'll withdraw the warrant, and you'll have to deal with that court. We're going to send this waiver of extradition down for you to sign. I wrote that in. What your requirements are is to either appear in Lawrence County, Kentucky court, get the warrant withdrawn, or be in this court in Chesapeake on the 20th at 10 o'clock and explain why you couldn't do that. You understand what you need to do, sir?
Yes, sir.
Okay, so this waiver of extradition form is going to be faxed to the jail for you to sign, and then after that happens, you'll get out of jail. Any questions, sir? Okay. Take care of this week.
Yes, sir.
That's all. Thank you.
Thank you.
Okay, we've got some recalls at the jail, but we're not ready to go back. Call those people back up, so we're going to come back to some hearings here in court.
State of Ohio recalls Heidi R. Taylor, case number CRB 2485.
All right, this was a recall. She was going to get her prescription.
Yes, she was able to access her prescription record on the CVS app. You want her?
Yes. Yes.
That one paycheck.
All right, she has provided proof of prescription for the drugs she tested for, so I'll treat this as a non-treatment case for sentencing purposes. Anything else, ma'am, you wish to tell me before I send you? Okay, I'll impose a $100 fine, order you to pay court costs, 10 days in jail, all suspended on the conditions you do 5 days of community service, 2 years of what we'll make it level 5 probation, your order to stay out of Walmart's and have a review hearing November 12th. So you got all summer, most of the fall to get this done. If you do, you don't have to show up. If you don't have it all done, you got to show up for a hearing or you get a warrant for not showing up.
Thank you.
She'll need to speak with Mr. Major, and then she's free to go after some time.
All right, thank you, Your Honor.
You're welcome.
State of Ohio recalls Ryan J. Plants, case number PRD 231541 A and B, CRA 19718.
All right, so there's some corrective action we need to take here.
Yes, I have somebody waiting outside to take him to treatment right now.
All right, so and this is Mr. Smith's case, and he's not here today, but you're agreeing you need to go back to the treatment, is fine?
Yeah.
Okay. We'll schedule you a month out and see what you're doing then. So let's make it June 14th.
Thank you, Your Honor.
You're welcome. Yes, so he's coming back.
State of Ohio recalls Brittany Eplin, case number CRB 23589 A and B.
Okay, we need Mr. Morford in the courtroom. You see the result?
I did see it.
Okay, well, before I say anything, we'll get him in here.
That's one of the two sisters.
Okay.
He said she wants to turn around.
Mr. Morford, we have Brittany Eplin.
Yes, Your Honor.
You want to come up to the bench first, so you can see the test results. I don't think he has it now.
Bill, what do you think?
The first question is, how does this happen? She doesn't have a pass. Is there a problem?
I had called somebody to talk to them about it, and we're reviewing the cameras right now to see how she came in contact with it. She doesn't have passes, she doesn't have phone privileges. I was told it kind of all boils down to the manipulation of everything that's been going on at the house.
I never did fentanyl, sir.
I'm sorry?
I never did fentanyl. I don't know how I got there.
Well,
I'm being honest. I really
sometimes people do it, they don't know they're doing it. Because if you get something that somebody hands you,
Nobody handed me anything.
Well, you want to screen again? I mean, we can do another screen and see if it's going to show a different result.
What's gonna happen to me? I
Well,
don't
if
wanna
you keep
go,
using fentanyl, you're probably going to die.
I don't wanna go to jail.
Jail's better than dying, and I've had people that have died on me, I wish I would have put them in jail.
His concern is about you dying. Do you understand that? Your life hangs in the balance right now.
Yes, sir.
If you're out using fentanyl, I mean, last year was the most overdose deaths in the United States ever. It's about 115,000 people, really. And a lot of people your age. You know, people your age don't usually die. But if you're going to use fentanyl, you got a big chance of dying.
Yes, sir.
So we gotta get that fixed,
Yes, sir.
whatever it takes to get it fixed.
Yes, sir.
I mean, do you want me to rescreen you again?
I mean, you can. Well, I want to know what's going to happen to me.
Okay, well, you're the one, I want it for you, Mr. Morford, everybody, hometown wants it for you, your family. You gotta want it. You gotta wanna change, you gotta wanna stop hanging out with people who are using drugs. That's probably the biggest one right there. If your friends, if your boyfriend is using, the odds are you're gonna use. So if that's what it takes to break up with him, that's what you're gonna have to do. Or he's gotta get clean.
You need to do.
And I don't know him, I don't know that he's using, but I just know, I've experienced some life here watching people go through this process, and that seems to be one of the biggest holdups. Is who are you with? Who are you hanging out with? That has so much to do with what happens.
Yes, sir.
Okay? Okay, go do another screen. But I'm going to be double convinced that you're using if it comes back 32. So go do another urine screen. Let's see what it shows. Okay, we have some new cases.
State of Ohio versus Amy D. DeMint, case number CRB 24-284.
Ma'am, are you Amy DeMint?
Yes.
The bailiff is bringing you a copy of your charge. It's an assault charge. It alleges that in Rome Township, May the 12th of this year, you knowingly caused or tried to cause physical harm to Bobby Ferris. That's an assault charge. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
You understand your rights? Were you here when I explained your rights of defendants?
Yes.
Do you understand those?
Yes.
Any questions before you enter a plea?
No.
What plea do you wish to enter?
Not guilty.
Do you want a lawyer appointed to represent?
Yes.
Do you have a job?
No.
Do you have no income?
No.
Yes, we've told her 20.
All right, I'll appoint Mr. Morford. He's seated right behind you.
Okay.
Entering a not guilty plea for you.
Thank you.
She's already posted a bond with Mr. Sowers.
That's fine.
Is there a protection order requested here?
Yes, Your Honor. And Ms. DeMint is already the subject of a case that was already turned over to a special prosecutor. And I don't know whether charges have actually been filed yet, but there is a conflict within the prosecutor's office involving that case. So we've asked that this one be sent to us, but the same, I think it's Mr. Ashworth.
All right. Attorney Ryan Ashworth will be appointed as special prosecutor. Okay, Bobby Ferris also is charged, so the co-defendant, let's go ahead and bring him up. So I assume that will be also turned over to the special prosecutor or not?
State of Ohio versus Bobby Ferris, case number CRA 24-282 and CRB 24-285.
It seems as if it would need to be. Oh, well.
He has a bond up also. He's got different charges. All right, so you're Bobby Ferris?
Yeah. think, Your Honor, given the cross-filing, maybe it's worth a discussion about whether or how the cases need to be dealt with. I mean, anytime there's a cross-filing, there's a kind of a built-in potential for a conflict. So I'd like to know what their relation to each other is, first of all. Stepdad and stepdaughter?
That's my girlfriend's daughter, and is.
Okay.
Do you all have any reason where you have to be together in the same household or anything like that?
You don't live together and under the same roof or anything?
We was planning to, but no, not now.
I can tell you why you have to stay there for.
If it has to do with your living situation.
Yeah.
Yeah, that would be okay.
Or Osborne, when he told me to leave the property when I was living up to the camper, he told me to stay with my mom until all this stuff gets situated with me and Philip. And he told me to stay with my mom. That is why I was staying with them for. Just so I can get me a place of my own.
Where'd you stay last night?
I was with my mom.
And she doesn't live with you, Mr. Ferris?
Yeah, she wasn't there.
Okay, but she doesn't live with you now? So if she's staying with her mom, that's okay?
We have a different place we're moving to.
But she didn't stay with her mom last night.
Yeah, I did.
I stayed with her mom last night, she did not.
He stays messed up on everything.
That's all.
Okay, well, here's the main thing I'm looking at. I don't want you all to be under the same roof where you're gonna fight and have another incident. Sir, what's your situation?
My brother has a trailer across from me that I own, and that's his residency. They were just living there. They have a new residency now out the country, farther apart. So but they had the protection order. They had both at the same address. Well, his address is the 245, and hers is out towards Scotttown. So they're separated now. There's two different addresses.
What's your name, sir?
Jeff Ferris.
Okay, thank you. So you two can stay apart from each other. That's the main thing I want to know. You got different places to go to where there's not going to be problems.
We do need to get his vehicle. He has a motor home at their residency right now, and I'll get it removed.
All right. So, Mr. Ferris, do you have, well, let me go over the charge with you. You've got a more serious charge. You've got aggravated possession of drugs charge, which is a felony 5. It alleges May 12th, Rome Township, you were knowingly in possession of methamphetamine. That's a felony of the 5th degree, maximum penalty a year in jail, $2,500 fine. And you're charged with assault. Assault is the charge that you allege to cause physical harm to Amy DeMint, also at the same time and place as the possession. Do you have a job? Do you have a...
No, I'm on disability.
All right, Mr. Steyer, I'll appoint you to represent Mr. Ferris.
Your Honor, who was I being appointed to?
Mr. Ferris.
Thank you.
There's bonds up for both of them, so I'll continue their bonds. I'll order them to stay away from each other, so mutual protection orders. Is that what you want each other, the other one, order to stay away?
Yes. You want him to stay away?
That's right.
Yes, Your Honor, mutual.
There'll be a protection order issued in for each to stay away. Bonds are continued. When do we want to come back? And what's the state's position further on bond for Mr. Ferris? Asking for assessment.
Yes, Your Honor. And as we often do in a situation like this, if Mr. Ferris wants to go ahead and avail himself of treatment, then we can strongly consider leaving the felony case here instead of taking it to the grand jury, as long as he follows through and is successful in the treatment, if he wants to do that.
Okay. That's the question, are you willing to do treatment?
I don't know, it depends on what results of your assessment are. Okay. We're willing to do that, Your Honor.
Okay. How do you pay for medical services? Do you have an automated medical card?
He has a medical card, Your Honor.
I have Medicare, Medicare.
Which is it, Medicare or Medicaid?
Both.
Okay, he does have Medicare, so that may complicate our process. Is OBP here?
They are not.
They're our best bet for Medicare, I believe.
I think that's true. So let me explain to you, your lawyer can give you a further explanation so you'll understand. You know, this is a misdemeanor court in terms of trial, so I do not try felony cases here. But I arraign people for felonies, and I have the preliminary hearing for felonies. And then in the normal course, it would go to the grand jury for an indictment, and you go to the common police court, which is in Ironton. So what the state is saying, if you agree to go to treatment, do well, get good reports, get clean, then they won't take your case to the grand jury. You won't get indicted. You won't go before the common police court, and you won't have any risk of going to prison. The felony court can send you to prison if you're convicted of a felony. You're not going to go to prison if you stay in this court, do well. In fact, they will probably dismiss your case on the possession if you get good reports and get clean on the treatment. Do you have a question, sir?
Yes, Your Honor. He just did he's worked with Shawnee too, and he just did a screening actually this week, and everything looked good.
Okay.
Well, he's charged with possession of methamphetamine, so that's not a good sign.
Yeah, but,
I'm going to caution you against saying anything on the record. We'll talk out there.
He can go get an assessment, and if the treatment provider comes back and says, oh, this guy doesn't have any problem whatsoever, you know, he's clean and good, that'll be good. But it sounds like, and this is very typical, there's mental health overlay of issues here too. So I'm not against him continuing to go to Shawnee.
Which Shawnee are you going to?
Shawnee Mental Health, I take it.
Colgrove, okay.
Yeah. The problem with them is they're not very cooperative about giving reports. And getting them to cooperate with the court is difficult. Now, there's other agencies that he could go to that could provide the same kind of service that are more cooperative.
Okay.
But anyway, if he wants, he has the choice. I mean, he can get treatment, get good reports, and a report saying he doesn't need treatment, and keep the case here, or he can just go on to the grand jury and he can talk to a different judge down at the county police court level after he gets indicted by the grand jury. I think Mr. Starr would probably advise keeping it here.
That's usually the best bet, Your Honor.
Okay, so I'm going to put him down for going to OVP because they're one of the few that can few treatment agencies can deal with Medicare.
I believe I heard that Mr. Ashworth had been appointed as special counsel on the other case.
Yes.
Special prosecutor. Do you know what Mr. Ashworth's going to be is scheduled to be at the court next?
I do not.
I would like to maybe try to unwrap that a little bit so that smarter minds than myself can figure out whether there needs to be a special prosecutor right now or not.
On Mr. Ferris?
On Ms. Dement.
Oh, okay, so you're not sure even now?
Well, here's what's going on. Ms. Dement is alleged
victim in another case, right?
She's alleged as a victim, yes, and Philip Thacker is the defendant in that case. But there's also, and Ms. Dement knows this because she's come to our office many times and been told this, that we referred a matter in which she would be the defendant if it's filed to the special prosecutor.
Where he's the complaint party.
Where he's, yes. So there's that out there, and now there's this. So we have her as a victim already, but maybe also a defendant. Maybe that doesn't matter as much as the fact that we have her as a victim already, and now we have her as a defendant. So probably a special prosecutor would be indicated unless she'd be willing to waive that, considering the fact that it looks like of course, I don't know if we've reached that level of conversation yet as far as how we're going to proceed with these two people. We've gone as far as getting protection orders for them. So I don't know whether they're going to agree to a 90-day continuance or whether they're going to want to pursue the charges.
Well, when can we have that sorted out? You want to talk, take a break and talk?
I was going to say, Judge, if you
Maybe we
want,
could recall these matters.
Yeah, let's let Mr. Ferris and Mr. Mann talk to their counsel and we'll recall it.
Ohio recalls Austin Hawthorne of the Lawrence County Jail, case number CRA 2357, and others.
Mr. Steyer, do you want the court's? Okay.
I'm good, thank you.
You said you doesn't. All right, we recalled this after Mr. Morford talked to Mr. Hawthorne. And how do you want to proceed, Mr.
Judge, first I'd like to address the failure to appear in January. He says that's due to a series of unfortunate events. Apparently, Judge, he has some history with treatment providers, more than one, and he wishes to return.
He was doing really good at the counseling center.
That's where he wants to return to.
But I take it he left there, or?
I don't think he made it there this time, Judge. I believe that he was
He
picked
was
up.
there. I remember seeing him on video. He was
Okay.
there.
He maybe got waylaid in Boyd County then.
I heard something about Boyd County.
Yes, sir. He was arrested, I believe, on his way, or close to the time he was supposed to return to TCC.
No, I left TCC in February, in January. I sold my car, had issues with my daughter's mother, so I got discouraged in the leaving.
I mean, this is a felony, so I don't know what the state's position is, if you want to let him come back and stay in this court or send it on to the grand jury or what.
Where is he now, in jail?
Jail.
I guess that Warren's was a giveaway. Well, is there someplace that'll take him back?
Counseling center says they will take him back.
We're okay with that.
Okay. All right, I'll do an order releasing Mr. Hawthorne. Now, do we want up the ante and put a monitor on him?
I think that's appropriate, Your Honor.
Do we have a monitor?
I don't know, Your Honor. I was just made aware of the jail, by the jail, that he has a failure to appear warrant out of Ironton Municipal Court too.
Okay, so
I believe he sees Judge Waldo this afternoon on that, Your Honor.
1:30 is what they're telling me, yes.
okay. Well, if we could get Judge Waldo to go along, we might let you go back to the counseling center with an ankle monitor. Do you understand what it means if you leave with the ankle monitor on?
Yes, Your Honor.
They're going to be able to find you really easily. Okay, so you know what happens sometimes? People cut the ankle monitor off because they don't want to be found really quickly. But there's really no place you can go hide with an ankle monitor on because they know they can see exactly where you are at all times. So some brilliant people, after I give them this speech, they still cut their ankle monitor off. You know where all those people are now? Prison, not just jail. They're in prison. Because adult probation supplies the ankle monitors, and they're about $2,000 a piece. And they get really angry when you cut off the ankle monitor, and they charge you with a felony, like escape, something like that. And it leaves me, I don't have anything to do with it anymore. It goes on down to, you get indicted, you go before the one of the two common pleas judges, and kind of my impression, they get angry about it. Because I haven't had anybody yet who's cut an ankle monitor off who didn't go to prison. And I'm not talking about, 6 months, 8 months, 9 months. I'm talking about 3 years in prison. I mean, that's the minimum. Corey Little, I talked about this last week. Corey Little, I told him, gave him this same speech. He lasted 2 days, cut his ankle monitor off and ran. He wound up getting 7 years because I thought he would get 3, but Corey had a bunch of other stuff out there that I didn't know about. So by the time they caught him, he wound up getting 7 years in prison. And he could have went to treatment and probably not done any time in prison. So I'm trying to tell you, Austin, I've had you, I feel like we're almost friends because I've had you so much over the years. I've kind of watched you grow up. And I know your uncle worked for us. This is really serious stuff. And if you're going to mess up and be tempted to cut your ankle monitor off, it'd be better off you just say, Judge, I'll just stay in jail. I don't want to go to treatment because I'm afraid I'll cut the ankle monitor off. Then I'm going to go to prison. And I don't think prison is a place you want to go to. Mr. Hill.
Your Honor, I've sent a message to John Kincaid to see what Ironton Municipal Court's feelings would be about allowing him out on the ankle monitor to go to treatment. So I'm waiting for an answer back from him.
Well, so after that speech, are you scared or you want to go on treatment?
With regard to my guidance, that appears to be complete.
Okay. Well, I probably had 4 or 5 people cut the ankle monitor off after I gave them this speech. Not one of them have ever said, Judge, you know, if you send me to treatment, I'm going to cut that ankle monitor. Everyone says the same thing you said. I won't cut the ankle monitor off. I'll stay in treatment. I want to do it. But I just want you're going to have thoughts about doing it. And when you do, think about going to prison for years.
I just know I've been sent, you sent me to treatment 16 times and I've completed 12. I've been treated track record.
You did pretty good the last time I sent you to treatment until you didn't do good. Until you did good until you didn't, and you left. Okay, so I'm on board with it. You gotta get Judge Waldo on board with it. So you're gonna see him this afternoon. Let's set it for another hearing. We got 29 hearing, pretrial set for the 20th, so let's go ahead and set it for then. So I'll see you next Monday. Either you'll be at the counseling center or you'll still be in jail because Judge Waldo kept you there. So I'm ordering him released on a $5,000 OR bond to the counseling center if Judge Waldo agrees.
Thank you.
You're welcome. And an ankle monitor.
State of Ohio recalls Kyle W. Hopkins at the Lawrence County Jail, case number CRA 245. Williams Spalding is on deck.
Kyle Hopkins, this is Mr. Morphe's case. What have we decided, sir?
Judge, he says he wants the opportunity to post bond. I've tried to
I
reach.
didn't interrupt you, sir, but I was just talking to my fiance. She's on her way to the court to pay the $1,500.
Okay, then you'll get out, and I'll have to modify this. I'll give you a week. So I'm gonna give you a week to turn yourself in Meigs County. If you get out today, you have to turn yourself in before May 20th, which is next Monday.
Yes, sir.
Or you gotta show up back here in my court on May 20th at 10 o'clock, explain to me why you didn't go turn yourself in Meigs County. Or I'll tell the bail monster to go fetch you, which he will do, and take you back to jail.
She still has to get to the bondsman, even if she was.
Oh, that's right.
Has to go to court.
No, if you post the 1,500, then you're just gonna lose the 1,500 and the warrant will still be outstanding. You're right.
Yes, sir. Yes, sir. I understand that. I just told her that she didn't have to use the bonds, and she brought 1,500 to your courtroom there.
You're correct. If it's a
she-
cash bond, then you just lose the 1,500 and the warrant still stays in effect.
Okay. Well, she's on her way to your courtroom, or to your court there with 1,500 cash.
You'll be out shortly after she posts that, sir.
Yes, sir. It might take her an hour or two, but I told her it had to be before 4 o'clock, and she was on her way.
Okay, I'm still gonna put it on my docket for May 20th to see if you did turn yourself in or not. So if you haven't turned yourself in, if you turn yourself in by May 20th, you get the whole $1,500 back.
Yes, sir.
If you don't turn yourself in, then it's gonna be forfeited, and the warrant
Yes,
will
sir.
remain in effect.
Yes, sir.
Okay, that's all.
Thank you.
I appreciate it, sir.
You're welcome.
State of Ohio recalls William Spalding at the Lawrence County Jail, case number CRB 23512, PRD 23697. Joshua Lee Turner is on that.
This is Mr. Stiers' case, and you had a discussion with Mr. Spalding.
I did. Mr. Spalding advises that he's previously provided proof of insurance on this case. I didn't see it noted, I didn't see it in the file. I went and checked, it's not been noted on the computer. Now, it's possible he's given it to me and it's in my file, but I didn't bring it today because I wasn't expecting him to be here, and I'm not certain of that. And for that reason, I don't want to plead him to the driving under suspension, especially because he believes he has a chance of getting his license back. So what I'd like to do, though, as we discussed, the offer that's been made is an agreeable offer for the Walmart charge. So, and I think he's actually already entered a guilty plea to that in the past, and we're just set for sentencing. But at any rate, he's going to go ahead at this time, just in case, and enter a guilty plea on that. And we would join in the state's recommendation that he be given 10 days in jail, 7 suspended, credit for the 3 served. I would leave it at the court's discretion whether you want to add anything on top of that, since he's actually spent 3 days in jail or not.
Well, here's the fly in the window. Back, he has pled before, and back when he did, I had him do a urine screen, and he tested positive for cocaine, so I wanted him to get treatment.
Well, that's
never happened.
I don't. It might be better if we just set this again, then, Your Honor. And I ask for an OR bond at this time, so we can deal with we have him here to deal with the substance issue. He's already entered the plea. We just set it for sentencing and set the other matter for pre-trial.
Well, the problem with giving an OR bond is he failed to appear.
I recognize that, Your Honor.
He failed to appear, and it wasn't like, you know, if he turned himself in, then I said, okay, I'll give him an OR bond, but I think he got nabbed, didn't he?
I believe he was arrested.
What's the state's position on it?
Well, we need him to do his treatment because that was part of either that or, I mean, he didn't show up, so he needs to have a cash or surety bond unless he's willing to submit to treatment and get started on that. Under those circumstances, we'd want him to be assessed before he got out of jail.
Would you be willing to do an assessment, sir?
What is that?
That means someone's gonna sit down and talk to you about substance abuse issues and,
Sure, yeah.
okay, he's willing to do an assessment. We could, how do you pay for medical care?
I have Medicare.
You have Medicare? Well, we're in the same boat we were in before. OVP isn't here, and I don't know that anybody else is gonna be able to take his insurance.
Can you post a bond, Mr. Spalding?
Pardon?
Can you post any kind of bond?
No, I don't get my next disability check until first next month.
If he, well, we've already entered the plea, so I don't know if that makes a difference, set it for sentencing.
What was his explanation for not coming before?
He was I believe he was in Florida on the date of the hearing. He has family in Florida, and he's been back and forth several times, and that's caused issues where he's gotten down there and hadn't been able to get himself back up here in time for hearings. That's been the issue once or twice. Now, I can't say that explains his absence between that date and today, but I think that was the issue that day. He was down in Florida.
Yeah, see, this isn't the only time, this is the second time he's failed to appear. According to my notes, there was a time in February 26th, he didn't appear.
I will say this, I think that the 3 days in jail has perhaps communicated to him the importance of actually showing up. I don't know that he was taking it as seriously as he would today, having spent 3 days in jail. I think this may have served as a wake-up call. And I mean, again, I don't have much to argue in that place other than the issue that, yes, he indeed has spent 3 days in jail, and I can't imagine that not communicating to anybody the need to appear when they're ordered.
Mr. Hill.
Your Honor, I'm just kind of meditating on the idea of the amount of freedom that a first person must feel to be able to go to Florida and not even have an idea how they're going to get back and not care. So, I mean, I think that he still has...
The problem is he did come back.
Well,
if he
that may
went
be
to
true,
Florida and stay, that's another animal. But he's a South Point guy, and he's, once that Lawrence County, South Point soil gets in your blood, it just calls you back, Mr. Spaulding. Can't stay away from it.
I think that's the thing about this area. If you leave once, you can stay away, but once you've come back, you're stuck.
So, maybe he could be sentenced to a bunch of jail time and ordered to go to treatment on probation, and then the next time, if he hasn't done it, he gets arrested again for something, then he could just spend some time in jail. I don't know if that's the way to handle it.
And Your Honor, that might be the way to handle it. And what we're saying here would be, instead of 10 days suspended, instead of 7 days suspended, you could have up to 173 days suspended, which would take you to 6 months in addition to the 177 days suspended, which would take you to 6 months in addition to the 3 days you've done now. And you can avoid that if you come to court and do your treatment that the judge is ordering you to do, but if you don't do either of those things, any time between 0 and 177 days, he could leave you in the jail. Although, again, we need to keep open the DUS simply because he does believe he can bring in proof of insurance and thinks he can get his license back.
So he has another reason to show up to court.
Right.
Yes, you can.
I know, I did, you said, you called me back to do another book screen because you may want it, but
You had one clean drug screen, but the first one was cocaine.
I think that... What are the dates on those, though, Your Honor? I think we might have gotten him retested pretty quickly, and the cocaine was gone.
No, it was a few weeks. Man, let me look.
Just...
January 2nd, he tested for cocaine and THC of this year.
Right.
And then I think it was March. March the 8th, negative.
Right.
Okay. I'll go ahead and sentence him on the CRB case number. 23-512, there's been a guilty plea, he'd already pled. $100 fine, court costs. 180 days in jail. Suspend 177 days. Give you credit for 3 days you've already served. Order that you get assessed and treated as indicated for, and this will have to be at ODP, so I'll refer you to Ohio Valley Physicians. And they're right in South Point too, so that's, they're close. Treatment as indicated. Okay, his review hearing I'll make June 28th. So you're coming back pretty quick. He's ordered to stay out of Walmart. $5 days community service. Treatment as indicated.
Your Honor, I'm available on June 28th. Do you want to take that date for the pretrial on the
Yes.
traffic matter as well?
Okay, so you got until June 28th to try to straighten your license out too. We'll set it as a pretrial.
And does somebody at the jail write these dates down for the folks while they're sitting there? Do you know? Okay, so they're gonna write that date down for you. You have to be there that day. Now, you've got my phone number, so once you're out of jail, please text me. We'll get in touch with each other and talk about things and get everything straightened out, okay?
So last Friday in June, he has to be back in court.
Thank you.
You're welcome.
Thank you, what's that? Okay.
June 28th.
State of Ohio recalls Joshua Lee Turner to Lawrence County Jail, case number CRA 24238.
Okay, so this, we were letting the state do some investigation on this and recall it.
Yeah, and Your Honor, during part of this process, I have realized that there may be a conflict of interest for me representing him. I was unaware of that prior to today. His family and I have talked to Mr. Holt. Mr. Holt's agreed to represent him. I believe the family's agreed to retain Mr. Holt's services. So
Okay.
I was unaware prior to the arraignment this morning, sir.
That's correct, Your Honor. Thank you. Your Honor, the mother's here, the child, so the defendant is the father, mother is here. She does not wish to have a protection order or proceed with the charges. That's what she's indicated to me.
Well, the state found out that there was an investigation by Children's Services, and they found the allegations to be unsubstantiated. So how this happened was the young man who's the alleged victim apparently was overheard at school saying that something to do with an accident on a side-by-side and also his father strangling him and doing other things. So that got the attention of the administration there at the school, and he was questioned about it. And then Children's Services was called in, and apparently the story changed, and they did not substantiate it. Now, they also say that there was a bruise of some sort on the young man's neck, but when they checked the rest of his body, there were no other signs of any sort of assault. I don't know what this all adds up to at this point. I know that he also, Mr. Turner, was apparently a victim of an assault yesterday evening, which got him arrested. So I don't know what all's going on. At this point, his mother's here, and she doesn't believe anything like this happened. She's also a defendant today, if I'm correct. You've got a case of your own. So I don't know what to make of all this.
Well, are you wanting to go forward with the cases, nolly them? How do you want to proceed?
I don't want to nolly them today, but we may not go forward with them. I just don't know at this point. And then the next thing that comes to my mind is the issue of protection orders. His mother, the young man's mother, says that it didn't happen.
We're all perfectly safe. My kids are perfectly safe.
And he's high school age?
Well, he's in 8th grade.
8th grade.
Yes.
Your Honor, we also, the gentleman who assaulted Mr. Turner is also, we've been told, one of the reporters that made the allegations. So that adds another twist to it as well.
Is that filed in this court or another?
I don't know if it's filed yet.
I have no idea.
I'd say you'll probably have
Um,
R&D.
Yes.
What township?
That would be Sims or Aid.
Yeah.
So it'd be yours. That might be Mason.
We think it's going to be in Ironton Municipal. That's where the alleged perpetrator lives anyway.
So what to do with that down there, I guess.
Well, if it's Mason, that's gonna be here.
Well, I live in Amazon, but they do on Mason, so that may be a top-down address.
So you're, what's the state's position on bond for the charges?
We're not opposed to no R bond. I'm still not sure about the protection order though, until I can get just I got communications with Children's Services just now.
I didn't understand what you said.
I got further communications from Children's Services just now.
Do you want
I'd
to
like
wait
to-
and then
I'd
talk
like-
to them further? or-
Yes, Your Honor. If we
Okay,
may.
let's let the prosecutor talk to Children's Services further, then we'll decide what the bond is after he gets
Understood, Your Honor.
talk with him again. So Mr. Turner will recall it. Okay, so we're going to go away from the jail for a while. We'll come back once we get the information from the prosecutor. We'll go forward. So we'll recall you, sir.
State of Ohio recalls Brittany Eplin, case number CRB 23-589, A and B.
We need Mr. Morford. Yeah, Mr. Morford's case. Well, I like the new song. All test is the same as the new test.
I will do better next time.
We need Mr. Morford. Mr. Morford in the courtroom, please. Mr. Morford, the new test is the same as the old test.
Really?
Yeah.
That's what I figured. What do you want to do? Do you want to save your life, or you want to run the risk of dying?
I'm going to save my life.
Okay.
All right, hometown still willing to keep her or work with her?
Yeah, I'm still willing to keep her this time.
Seems to me like there needs to be some sort of investigation, and Ms. Eplin, will you be honest and truthful? We're going to ask you some questions.
Yes, sir.
This didn't happen by magic.
Yes, sir.
June 3rd is the next hearing.
I'm good then, Judge.
All right, June 3rd, and I'd be interested to see what hometown comes up with as their investigations, how this occurred.
I'll keep you updated.
Thank you. June 3rd, 10 o'clock.
Thank you, Your Honor.
State of Ohio recalls Brittany Seitz, case number CRB 24187.
And Your Honor, Megan Turner's the co-defendant in this as well, if you want.
All right, Brittany Sykes and Megan Turner. Who's your attorney? Who's your attorney?
I do not have one.
Okay.
Well, I spoke to one, and he said that he didn't feel comfortable taking my money.
State of
So,
Ohio versus Leah Megan Turner, case number CRB 24188.
Okay, both these cases are set for pretrial today. And did I consider you for a court-appointed attorney before? Did you want a court-appointed attorney?
me?
Yes.
No.
Okay. No, I didn't consider you, or no, you?
Well, no, you didn't consider me one, but I had talked to Jenna, and she referred to Mr. DeLauder, so I talked to him, and he didn't feel right to take money for something that he felt would be dropped.
Did you felt what?
Would be dropped.
Okay, well, let's see if that's gonna happen first, then, before we go further.
sisters, okay. Have we talked to Kelsey? Is she okay with this?
Yes.
Okay. Yeah. Okay. We still have protection order?
Yeah, and that's staying.
Sound statement of procedure.
Your Honor, we've spoken, it's a matter of three sisters, and the alleged victim is the third sister. And she just wants to be left alone at this point, and she's okay with a 90-day continuance with protection orders in place and an agreement that if there aren't any further problems, that the charges can be dismissed after 90 days with the payment of court costs.
We're in agreement with that, Your Honor, and Ms. Turner indicated she was in agreement too.
Yes.
Would August 12th work?
Yes. I'll continue both matters to August 12th. You just want one court cost?
Yes, Your Honor.
Okay, who's going to be responsible for paying court costs?
I can do that, Your Honor.
All right, so that's on Megan Turner.
Uh-huh.
AJT.
Yes.
Can you have Leah sign that?
So as long as there's no further problems, the costs are paid on Ms. Turner's case. The case will be dismissed on August 12th. There's time waivers until then.
Thank you.
You understand, Ms. Turner, you don't have a lawyer. Ms. Sykes has a lawyer, an advisor. You have a right to make the state bring the case to trial before then, but you're, by agreeing to this arrangement,
Yes, I'm
what
good.
we call a time waiver. You agree with that? Okay, August 12th.
Thank you, honey.
And Your Honor, can they pay court costs prior to this if necessary?
Yes.
Okay. You don't have to today if you want to, you can.
State of Ohio recalls Samantha Cooper, case number CRB 2472.
Mr. Thompson's case set for pretrial.
She had the date mixed up, so can we give her 7 days?
Yes.
Okay, thank you.
May I approach, Your Honor?
Yes. Well, in fact, I'll give her, if she's compliant, I'll give her more time.
She is compliant. I know she works a lot. She's been trying to pay off a lot of fines.
Okay. Let's continue it then. Since she's compliant, got a good report. June 10th.
Thank you, Your Honor.
Thank you.
State of Ohio versus Tyus Ferguson, recall case number CRD 24641, PRC 23506A and B.
Oh, yes. Okay. Your Honor, we found out about the warrant. It was for a failure to appear here for a review hearing.
Okay, it wasn't a felony warrant then?
No.
So we're gonna go ahead and do a sentencing on 24-641.
I don't know. I mean, I don't know if he's got other stuff on the prior OVI that has to get done. I don't know. No, I'll give my recommendation.
What's the state's recommendation?
Well, Your Honor, it was an active OVI suspension, and so there is a required 3 days in jail, and we don't take any position on any other sanctions.
Mr. Counsel?
We'll change our plea based on that. We're wondering whether you could stay that execution of the jail time for about a month.
What's gonna happen in that month?
He's working.
Well, here's the problem that I have, is that, I mean, he got convicted in this court of an OVI August 25th, 23. What has he done on that?
I win. You can tell the judge what.
I can have everything taken care of by that month date.
He failed to appear for the first review hearing.
Yeah, honestly, I had the date mixed up.
Got arrested and posted bond.
Yep.
And that was in March 30th, and he still hasn't done anything.
I just started working last Monday.
Well, you could have done your community service then.
I haven't had a ride. That's what I was explaining to him. My mom's in nursing school and she works midnights.
And to me, it's unacceptable. You get an OVI conviction in August, and here we are in May of the next year, nothing has happened on it. So I think he needs to go to jail today on the driving under suspension. Anything else you want to tell me, Mr. Ferguson?
No, sir.
Okay. On the 24-641, has a $250 fine, court costs, 10 days in jail, suspends 3 days to be imposed immediately. Review hearing. Going into July. July 15th will be his review hearing on that case and on the OVI. So that's on 23-506. So we need to have something done on the OVI then too.
Yep, it'll all be done.
So he's commanded into custody at this time.
State of Ohio versus Sid Mosser, case number CRV 24-258, TRC 24-481. This is Mr. Stratton's case. I understand he's here on Zoom.
Mr. Stratton, are you there?
I just like to take one.
Mr. Stratton?
Yes, sir.
Okay.
Can you hear me?
I can, loud and clear. Sid Mosser is your client. He's here, case number 24-258, 24-487. He's here.
Yes, he was in jail. We left this on, but he was in jail. They closed the bond. So this happened to be set up for a retrial.
Okay. It was 1,000 cash security you posted.
Yes. It ended up being like 200, Your Honor, we posted. I was in jail for what, 9 days? 4 of which, something like that, most of which I wasn't even able to use the phone. Kind of had a problem with it. Kind of wrong.
Okay, is there days coming up, Mr. Stratton, you're unavailable?
Yeah, any days up to 20th of May.
Time is up. Every day in May is just slammed.
Well, we can go June, Your Honor.
June's getting close too. Let's make it the 10th. June 10th will be the next hearing.
Sure.
Sounds good.
You want to write that down, Mr. Mosser?
Yes, Your Honor.
Right there in the basket. There's a form for your next hearing date.
June 10th at
10.
10.
10 at 10.
And we need a time waiver too, Your Honor.
All right,
Okay, June 10th at 10 is Mr. Mosser's next hearing. Defendant waives time concerns.
Yes, thank you, Your Honor.
Sure.
State of Ohio versus Kara D. Hearn, case number CRB 2381.
Okay, Mr. Stratton, this is your case.
Yeah, Your Honor, she's at Bethesda study.
I'm getting a report now.
May I approach, Your Honor?
Yes. Thank you. Okay, it's a report that says she's compliant with treatment requirements. There's still things she's working on.
She's actually doing really well.
Good. And another month? June 14?
June 14, Your Honor.
June 14.
Thank you, Your Honor.
Thank you.
Thank you.
Good job. Good job, Ms. Hart.
Thank you.
Thanks.
State of Ohio recalls Amy DeWitt, case number CRB 24284, and Bobby J. Ferris, case number CRA 24282, CRB 24285.
Okay, this is on recall to decide when to come back and what the bond, well, there is a bond, I think, for both of them.
My client doesn't wish to ask for a special prosecutor, Judge.
Okay. Mr. Sire.
I think that wasn't even an issue for Mr. Ferris, so it remains a non-issue. Mr. Ferris raised the issue, and I wasn't in here, of whether he actually had entered a not guilty plea or not. And just in case he hasn't, we're going to enter one.
He's got a felony, so I don't ask for a plea on a felony.
Well, I do that, but I know if there was a plea on the other matter, so that'd be fine, Your Honor. And we are willing to agree to a 90-day continuance if the other party is willing to so agree. We would ask that the protection orders remain in place during that 90-day continuance, but we're not necessarily interested in a conviction down the road.
My client is the same thought, Your Honor.
Okay, I'll do that on hers. Now, he's not going to come back because he got the
Right.
possession.
Well, I was thinking we could maybe set his for the same date as hers and at an earlier date as well, and just build toward both.
I'll set Ms. DeMintz for August 12th. Is there cost requested on this?
We would request one cost, so I don't know who wants to pay that.
Half cost?
It's hard to do that.
Would you?
We'll have to put it on one case.
One or the other has to pay the court costs, which will be, what are court costs now? They're
125.
125, so.
Plus,
Plus the $25.
So it'd be about $150. Well, one or the other, you have to pay it. Are you willing to pay it? But the case doesn't get dismissed. The case doesn't get dismissed. We may have to deal with that.
Okay, we'll deal with that on August 12th. I'll have to be here then. So I'll set both for August the 12th on the, I think those were assaults, you said, yeah.
Yes, Your Honor.
Pre-trials. And then on Mr. Ferris, he needs to go see OVP, get evaluated for his possession charge and deal with that, get some treatment, get clean. And I want to see him back on the felony matter, and there's a time waiver until he comes back.
Yeah, we'll waive time constraints, Your Honor.
June 3rd.
I have a jury trial set June 3rd. I'm here.
How about the 7th?
I'm here the 7th.
June
I'm actually
7th.
already on the docket. So,
June 7th.
can you give me one of those?
Yes, sir. One of the ladies is going to talk to you about this.
So have you given him information how to get in touch with OVP?
Yes, we've got a phone number for him to call.
Okay.
All right, you're good. So, you're free to go. Thank you.
Thank you.
Be sure to call OVP when you get out of here. Okay.
Thank you, Judge.
You're welcome.
State of Ohio versus Kimberly Turley. Case number CRB 24283. Kimberly Turley.
So this must be an arraignment. Amber, you Kimberly Turley? They'll bring you a copy of the charge. It's alleged, ma'am, that on May the 10th of 2024, in Fayette Township, you tried to defraud Walmart property without their consent. That is a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Sorry. Maximum penalty for this is 6 months in jail, $1,000 fine. You understand the charge, ma'am?
Yeah, I understand the charge.
You understand your rights?
Yes.
You plead to this charge.
That I'm not sure.
Well, if you're not sure, you should enter a not guilty plea.
I want to get this over with as soon as possible. I don't
That's
want
not,
it to drag
you know,
on.
if you feel like you're not guilty, then you should enter a not guilty plea. Getting it over is not a good reason to enter a guilty plea.
I'll just do no contest then.
No contest, well, that usually results in a guilty finding. What you're telling the court is, I'm not admitting that I'm guilty, but I'm not denying it either, and I'm agreeing that you can find me guilty without a trial, without a lawyer, if you think that what the state says it has as evidence is legally sufficient to convict me. And I'm just gonna hear their side of it, I'm not gonna hear your side. Unless you tell me, then change your mind, well, I don't think I am guilty, then I can't make a decision then. So, is that what you want to do? You want to let me just hear their evidence and make a decision?
I guess I'll do not guilty.
Do you wish to be considered for a court-appointed lawyer?
Yes.
Do you have a job?
No.
Do you have any income?
No.
All right, Mr. Morford, I'll appoint you. Well, wait a minute, Mr. Holt, do you want to take a point? I have an appointment.
I'm okay, Your Honor.
Okay, I'll appoint Mr. Morford. Not guilty pleas, and she has a bond up. This is case number 24, CRB 283. June 14th for pretrial.
That's good here, Judge.
June 14th will be the pretrial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Laura Nicola, case number CRB 24286.
Ma'am, are you Laura Nicola?
Yes.
Ms. Nicola, it's alleged that at Fayette Township, May the 10th of this year, you tried to deprive Walmart of property without their consent. That's a theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand the rights you have as a defendant? Yes. How do you plead to this charge?
Guilty.
Guilty means you're admitting it's true and you waive the rights to have a trial and a lawyer. Do you understand that?
Yes.
Okay. I'm going to have you do a urine screen before I sentence you. So go out in the lobby and you'll be directed to where to go to submit to the urine screen, then you'll come back and I'll sentence you after I get the results. Go do a urine screen.
State of Ohio versus Kayla Holbrook, case number CRB 24287, A, B, and C.
Ma'am, are you Kayla Holbrook?
Yes.
Ms. Holbrook, you get 3 charges. I'm going to go over you with. The first, have you been here when I've explained defendant's rights?
Yes.
Do you understand those? Have any questions about your rights?
I understand.
Okay, the 3 charges are menacing, resisting arrest, and criminal damage. On the menacing, it's alleged that Mason Township on May the 10th of this year, you knowingly caused Brittany Kazee to believe you would cause serious physical harm to a person or property. That's aggravated menacing. It's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine. 287B alleges that you resisted the lawful arrest of yourself on May the 10th. That's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. 287C is criminal damaging. It alleges that on May the 10th, you created a risk of harm to property belonging to Brittany Kazee. That's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand these charges?
Yes.
Do you understand the rights you have?
Yes.
How do you plead to these charges?
Not guilty.
Do you wish me to consider you for a court-appointed lawyer?
Yes, sir.
Do you have a job?
Yes, sir.
What do you do?
Work as a cook,
Where?
Sims Valley.
How much are you paid there? I have to determine your gross annual income.
$12 an hour.
Okay, how many hours a week do you work?
Normally about 20.
Oh, so you're part-time?
Yeah.
Okay, well, you're eligible then. Mr. Steyer in his office.
Thank you, Your Honor.
Thank you, sir.
Okay, I've entered a not guilty plea. To appoint Mr. Steyer. She's posted a bond, so that's continued. Protection order requested.
Yes, Your Honor.
So it'd be an order for you not to go around or contact Brittany Kazee. Is that a problem?
We're neighbors.
How close together?
Directly.
So just
But-
don't interact. Can you do that?
Oh, I can do that. They're getting evicted in about a month, so.
Okay.
Just stay away. they approach you, or she approaches you, just go into your residence and call the sheriff.
Side of here and here.
June 14th.
Is there any way that we could do a different date?
What's the issue with that date?
We're supposed to be in Oak Island and we already paid for a rental car.
What's the time frame of that?
Oh, we're going to be gone, what did he say, June or July?
He said June 14th.
Oh, June is fine.
That's a
June is
Friday.
fine.
June 14th.
I'm
Okay.
sorry, I thought he said July.
We're good then, Your Honor.
Okay, June 14th is the next hearing, will be a pre-trial at 10 o'clock.
All right, I'm gonna get your file from before. Wait for me out here.
Okay.
I'll be out there with you in a minute. Thank you. Thank you, Your Honor.
You're welcome.
State of Ohio versus Nicholas R. Adams, case number TRD 20-1480. Nicholas Adams.
Nicholas Adams. Okay, pass, he isn't here.
I believe it's for sale.
He's not here.
Okay, I didn't know you wanted to have.
It was a bond forfeiture hearing.
Oh, okay.
So, I don't know if he walked in, but he's not here now, so
Okay.
his warrant should remain in effect.
Do we want to put a new day or anything on forfeiture?
It's actually set for May 31st.
Okay.
For bond forfeiture.
Okay. That is left in.
So, I'll let Mr. Sowers know. So he must have came into the office. So his bond forfeiture remains in effect for May 31st.
State of Ohio versus Christopher Russell, case number CRA 24256. Your Honor, he has been picked up by Green County.
So on that, Nicholas Adams, I guess the warrant needs to be reissued. All right, Christopher Russell waived extradition to Greenup County, Kentucky, and he was picked up by them before today, so his case is dismissed.
State of Ohio recalls Laura Nicola, case number CRB 24286. Laura Nicola.
Okay, ma'am, are you on any kind of prescription medication?
Just hypertension.
Okay, well, I don't think that would be a barbiturate, would it?
Never in my life, I swear to God, I use drugs. Never in my life. If no, I can repeat the procedure again.
And I've got a South Chesterfield, Virginia address for you.
Yes, I live in Virginia.
What were you doing here?
In my country, in my religion, the last week was the Easter, and I came from Kansas City, there where my relatives was, and I was trying to go in Virginia.
So you're just traveling through here?
Yes, I was with my sister-in-law, and she entered in Walmart with me and her baby, and she took some stuffed baby. And I'm really sorry for that, and do not have her ever again.
Mr. Hill.
Well, Your Honor, I mean, she tested positive for something illicit, is that right?
Barbiturates, it says.
But she lives in Virginia, and she was just passing through. Apparently, this Walmart has a reputation for people who go there to steal. I don't know.
I don't know if we just catch people here, or people, if it's like a magnet for people, because they come from all over. For some reason, the Lowe's is right next door, and they never go to Lowe's. Nobody ever gets caught, maybe I shouldn't say that very well. Nobody ever gets caught at Lowe's. But how many people we had today from Walmart?
4 or 5.
A ton. Why do people keep going to Walmart? I don't understand it, people. You're gonna get caught if you go to Walmart. This one almost smacks to me of a plan, more of a plan ring type thing, because of the amount and the way it was done.
That was on my mind, too. Apparently,
Can we do some sort of, have you done some sort of history on this to see if there's any priors, other jurisdictions? Because it's alleged the amount that she was taking was almost $500.
I can ask for a criminal background check and probably get it here just real fast.
Let's do that. Okay, and were you not to depart the courthouse? And I'll have you back after I get a criminal history on you. Your case will be recalled.
State of Ohio versus Darrell L. Runyon, case number CRB 23529.
This is Mr. Morford's case. Supposed to be at the Counsel Center.
I missed his last 2 appointments.
Yeah, I had a reason for that. I had to go to, I had a reason for that.
And is he going into Ironton's where he's being seen?
Yes, Your Honor.
I've been clean for the last month.
He has provided all clean screens every time he screens since he's been with us.
Okay, that's good.
His next appointment's Thursday.
And I will be there. I just have to have transportation to take me. I don't have a vehicle right now.
Where you live?
I live in South Point.
Okay.
Or Burlington, I mean.
I'm pretty sure we can arrange that.
If you let them know, they said they can help you with the transportation.
Yeah, I'll call them and remind them I need help. I had a car and I was going to start driving my car, and then I found out my license was suspended. And then my brother took my car back. That's what that argument was about with him. So.
Okay.
Yeah.
All right, so you're going to give me better reports this next month, right?
Yes, sir.
Okay, June 14th.
June 14th.
I'll be there.
I know you will.
Yeah, over.
10 o'clock, June 14th.
Thank you, Judge.
You're welcome.
State of Ohio versus Stephen Baldwin, case number CRA 24248.
Good butch.
So it's my understanding he's at ARC, or he was?
Yes, Your Honor. I spoke with Brandon from Minute Reads earlier, and Mr. Boland's still in crisis stabilization at ARC.
Okay. I guess probably a pretty good place for him to do this.
That seems like where we need, for the time being at least. So if you'd like to set this out again, you know, what the state's preference on this is in terms of timing.
How long will they keep him there?
Just depends on how fast they can get him mentally stable. Usually it's no more than 10 days.
And then what happens after that?
Then he'll be going back to Minute Reads.
Was he on electronic monitoring already?
I'm pretty sure.
Is
Says that he is.
I guess, I wonder if he is now.
Probably, yeah. Yeah, I would say.
Okay. Well, we're okay with, and you've made a suggestion.
I made a suggestion of competence. The time is told at this point.
That's fine.
Well, this is a felony, though. We need to get it, because I'm not going to order an evaluation because of the position that they take.
We're going to present it to the next grand jury.
Okay, the 22nd?
Yes.
Okay, we want to come back on the 24th, hopefully we got an indictment then.
I am available the 24th.
All right. Next hearing for Mr. Baldwin is May 24th.
State of Ohio recalls Joshua Lee Turner at
Thank you.
Lawrence County Jail, case number CRA 24-238 and 239.
Mr. Bolton's case.
May we approach you?
Yes.
But my thing is that we need a protection, but why doesn't the CPS do it when they come in and question Jay right that out over a month ago? Instead of doing it now? Because he's been with us since, he's been in the house. So I don't understand why we need him now, if he didn't feel like we needed one a month ago.
Well,
The only other place we'd be able to say is the house is beside us, which when I say it's beside us, we own a 400-acre farm, so. Because I don't know. Our house is up this way and we have a long driveway to the driveway. It's back there. I'm just not because if he said he's clearly not abused, he felt like he was, then this would have happened a month ago instead of happening now.
I understand. That's two different stories.
Correct. Yes.
And then we also, I mean, I'm just going to be honest with you. I know I want to make sure you're here on a charge, but I know your sister, I don't know if there's two of them. But, and then your husband, we like they say, your husband, when he had people. Okay, so I'm trying to make sure that we don't have any, I'm not including anything. Okay, by children's services, look at it again, just to make sure.
So what about the school not even contacting you about this? They never do.
I don't know.
Okay.
I mean, that's,
I was just wondering.
yeah, that's fine. You can ask the judge. I don't know about how close you're. We're discussing, Your Honor, the issue of the protection order. And Ms. Turner says that they have two houses on the same property. Now, I don't know whether that's a sufficient separation to make sure there aren't any problems.
Since it's a large acreage property, they're not sure.
We own 400 acres. But like our house is closer to the road this way, and then if you're looking at our house to the right, we have a longer driveway to where our other home is. So he said 50 feet, that's probably, 500 feet, that's probably accurate, but I'm not a football player either, so I don't know what yards are either.
So 2 football fields. Is that almost 2 football fields?
Yeah, to be in the front yard, because there's the driveway's long enough. In the worst case scenario, he can go stay up in the barn at the farm, which is farther away from our house, if that is easier.
We would come back this Friday if the court wants to set it that soon, and we just want to make sure that we don't have a problem.
Your Honor, I mentioned that to Mr. Hill. I have a hearing in juvenile court starting at 9 a.m. If we could do it later in the docket, I could be here.
How long do you think the hearing will take?
Hopefully not too long.
Well, I'm not going to be here Friday either, so I don't know if that makes a difference. I can make notes, but...
Oh, if we're not doing it, I can, yeah, if we're going to move that, I can be here.
Well,
Sure.
I don't know if I'm on that.
Either way, I think I should be able to be here by, I would think noon or 12:30.
Okay. Okay, I'll set it for a hearing this Friday, the 17th.
Do I need to have, I'll let you because I live with them and it all happened.
So are they coming here Friday?
So preliminary and pre-trial. No, we'll just regular. $2,000 signature bond with an order to stay away from the minor until at least
How about the
Friday.
initials?
AT. A is an apple, T is an apple. Okay, next hearing is Friday at 10 a.m. Thank you. It'll get released today.
Well, his name is Lincoln, but he was not sure. I'm sorry.
Okay, that finishes up at the jail. That's the last hearing we have here.
Well, he's the one. She doesn't sign it.
Oh, that's right. Sorry. Because you were standing right here.
State of Ohio versus Christopher R. Hale, case number CRA 2344, CRB 2487, and CRB 1964.
Mr. Steyer's case.
Now, correct, Your Honor.
Yes.
It probably will be anyway, but we'll see what he says. Okay. If anybody does, we'll ask. Okay.
Okay, it's a good report.
Your Honor, are you able to tell me how much community service I have left? If that's not an issue.
Okay, on 2487, you got, I'm looking at the file, it's like 90 hours. 1964, 30 hours, 120 hours.
Okay, is that all total? Because I've been coming, I've came probably about 10 times to it.
Well,
it may not be completely up to date. If you've come 10 times, we would expect that would take 60 hours off that, but that would leave another 60 hours if that's correct.
Okay.
Correct.
All right.
But
I've came at least 10 times, I think.
Well,
I've been trying to come here. I got my schedule adjusted at work so I could come more often and get it done.
what you want to do is sit down, is come on a day that's not a court day and talk to, probably either, but Josh would be the one to talk to you specifically.
Okay.
But if you can speak to him or to Mr. Major, either one of them could probably help you out with that.
Yeah, I've definitely been coming then.
All right, so another month?
That puts us at around June 10th or 14th. Does that work for you?
Yeah, the 14th.
Okay. But the 14th would be good if we could do that, Your Honor.
June 14th.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Good job, man. Thank you, sir.
State of Ohio versus Danielle Ham, case number CRA 24229.
Sam, is that Bethesda or Lawyer Mr. Steyer?
Madam Clerk, Your Honor.
Yes. Okay. So a good start?
She's doing well.
Good. How do you feel, ma'am?
I feel great.
Good.
Very thankful.
Glad you're taking advantage of things.
Thank you.
June 14th?
That'd be fine, Your Honor.
Next hearing is June 14th. You're on the right track. Keep it up. You're doing good.
Thank you. Thank you, Your Honor. Thank you, Your Honor.
Keep it up. That's for you.
Okay.
Thanks.
State of Ohio versus Dean J. Fields, case number CRA 23715, CRB 23656.
Thank you.
All right, this is Mr. Delauder's case.
Mr. Fields is there on Zoom, Your Honor.
Okay. How's the state going to proceed on this?
Your Honor, we have discussed this matter and we've consulted with the alleged victim in this matter, in the remaining matter, and that's the theft offense. And it has to do with some property belonging to an association, a housing association, what's it called, Lake Forest?
Lake Forest.
Yes.
And so their primary concern was making sure that there weren't any more problems involving them and Mr. Fields, which, and they really weren't as concerned about the mechanism that got us there. And so we had agreed to recommend that we would amend the charge to a disorderly conduct, fourth-degree misdemeanor, and recommend a suspended 10-day jail sentence, a probationary period to ensure that the order that the court makes is still in effect of 2 years, but we wouldn't ask for it to be reporting because I think he's going to live out of town maybe. And an order as a condition of his probation that he stay away from that property, from the Lake Forest property. And if he does that, then that would settle matters.
Yes, sir. I've talked to Mr. Fields about that, Judge. He understands that recommendation. That is his intention to enter a no contest plea to the amended charge of disorderly conduct and stipulate to facts sufficient for a guilty finding.
All right, now.
And he is out of town. He's in Louisville currently and on his way to Montana, and he probably, he doesn't intend to be back here in the next several years. And then there's a sentencing hearing on a domestic violence to which Mr. Fields already entered a guilty plea.
Right.
And if you recall last week.
M1.
Yes, it was. And last week you had us continue these hearings to today, asked me to get Mr. Fields' signature on a protective order. So I emailed it to him, went over it with him. He signed it, emailed it back to me, so we have that. And I think you wanted him to acknowledge on the record that was his signature.
Okay, is that correct, Mr. Fields?
And Josh, the judge is asking.
Yes, yes.
Okay. And that's your signature on the protection order document related to Sarah Fields, right?
Correct.
I'll present that back to the prosecutor's office, Judge.
Okay, on 23-7-15, the domestic violence, is there a recommended sentence on that?
The recommendation, Your Honor, was a suspended sentence and condition that Mr. Fields not go around Miss Fields.
And she lives at Lake Forest?
She does.
Okay.
Their divorce is final now, and so those issues have been resolved.
All right, anything you want to tell me, Mr. Fields, about either one of these cases?
Josh, is there anything additional that we need to tell the judge? He's asking you. You don't have to say anything if you don't want to.
All right, on 7-15,
Can I have the new section number?
this is the same.
Oh, okay.
It's correct. This is,
Hold on, let me get
it changed the degree, so that's already been done. Okay, so the fine will be $200. Plus costs. 10 days in jail suspended. Order him to stay away from no contact with Sarah Fields and Lake Forest. I said it's a review hearing for November 12th, 9 a.m. No, I'm taking out the community service, so there's no community service. We'll make it 2 years of level 5 probation, which means no reporting of them.
And Your Honor, just for your information, the fine, if you impose a fine in the case, I've talked to Mr. Fields about that.
2 years.
Oh, I'm sorry, I interrupted you right in the middle of yours.
I was looking at what she's putting on, it should be 2 years. Go ahead.
He's going to make arrangements with me over the next week or two. I'll collect this fine money from him, and then I'll bring it, next time I'm up here, I'll bring it up, and we intend to get that paid off in full relatively quickly.
Okay. So that concludes 7:15. And then now there will be a change on 23-656 is amended to disorderly conduct. So 29-17-11?
Yes, it is.
29-17-11.
What was the number?
29-17-11. No, you got the case of 23-656.
Okay. So that, so we're deleting that?
Changing the section of 29-17-11.
Sorry about that, Judge.
It's okay, 29-17-11. I'll impose a $100 fine. court costs, 10 days suspended. Okay, I think that's, make it the same review date, November 12th, 9 a.m. That's it.
And then, Your Honor, the only other thing that Mr. Fields asked me to bring to the prosecutor's attention, the restraining order in the case, there's also a civil protection order out of common pleas court, is supposed to limit communication between Mr. Fields and Mrs. Fields to matters involving their children only. Mr. Fields has indicated to me that Ms. Fields kind of texts him a lot about things unrelated to the children, so I've directed him just not to respond to them, but maybe the prosecutor's office could reach out to her and let her know to cease that kind of thing. Anything else on these cases, Your Honor?
I don't think so.
Okay, thank you.
Thanks.
Josh, you can log off.
Thank you. State of Ohio versus Shannon Ellis, case number TRC 231630, A and B.
May I approach, Your Honor?
Yes.
TRC 231530.
I don't need that, I made 3.
Read 4.
Well, look at that.
Screens and the report are good.
Yes, Your Honor.
Good.
It's all good news.
And I think things are, she had a, if you remember, Your Honor, she had a severe medical emergency last time we were here prior to that, so I think things were looking good for that as well. She had a significant surgical procedure.
I think you were out, Mr. Hill, last time.
You're doing okay?
Yes.
Good. Your Honor, you know, given what we've been dealing with Ms. Ellis and wanting to make sure that she got all the help that she could benefit from, not sure whether we would feel comfortable going ahead and asking for the case to be sentenced just right yet. I want to make sure that, unless there's something in here that I've missed that says that we don't have any need to continue to work with her.
We're fine with that, Your Honor. As you know, Ms. Ellis is familiar with what the typical recognizes best course in treatment, so she has no objection to coming back and court monitoring this as we move along.
All right, why don't we go into July then before we come back?
Okay. Is there a date that works, where the court would like to, Mondays or better?
What's your availability?
I'm good with any day, it's fine.
Whatever works for you, Your Honor.
We have a bunch of jury trials demanded in July. So so probably a Monday would be best.
Okay.
15th, 22nd,
Either works for us, Your Honor, whichever the court prefers.
okay. July 15th.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. Keep it up, you're doing good.
Thank you.
Federal Hire versus Shannon L. Lewis, case number PRC 23427, A and B.
May I have that, Your Honor?
Yes.
We added Mr. Lewis to the docket because we had sent in certification where he had been in treatment so that he could get his license back, and they said they needed an order from the court in order to let that count.
Let's see. His sentencing order went on June 26, 2023. He's got at least a 1-year suspension, which he is up April 20th.
Yeah, you give me a work permit to drive back and forth to work, but I'm
He's
trying
got
to
the
get
blow
my
and go.
license. I got the blow and go and the yellow tags.
Well, I'm not, because I didn't order the driving intervention program because it's a multiple offense. I ordered you to go to treatment, which you did do. So I'm not really sure what it is you're saying that he needs.
When we sent in the information, the gentleman told him that he couldn't find the order that said that treatment was counting for his course. So maybe if we can get a copy of that order.
You can get a copy of this order. He wasn't ordered to go to the driver intervention program. He was ordered to get treatment.
Okay.
Yeah, the AI remedial driving course, she asked if last time I was here, treatment would count towards that, and you said it would.
Well, if I said that, I was confused because that would be on a first offense. A first offense, you're required to go to the dip school. On a second offense, you're not required to go to the dip school. You're required to get more extensive treatment, which he did do. So, I mean, you could get an order from us saying you completed treatment or you satisfactorily are doing treatment, but your action, the order says your suspension was from April of 2023 to April of 2024, so that's over.
So could we get a copy of that order so that we could send that to him?
Yeah.
Remedial.
Well, yeah, I don't know what that means about reducing points. Does he have a point suspension then?
Do you have a point suspension?
I don't know.
We'll check into it, but if we can
Yeah.
just get that order and fax it in.
Yeah, it's in the file. You can get a certified copy from the clerk.
Thank you, Your Honor.
You're welcome.
Federal Hire versus Austin Pritchard, case number CRA 18-1233 A and B, CRB 18-1234 A and B.
He's back in the back, Your Honor.
Okay.
For request for the common police court formation. On the request.
I'll see you after while they go to get a copy of it. Okay, Austin Pritchard he had a warrant out of this court also, did he not?
He was scheduled for today, Your Honor.
Scheduled, okay.
I'm not sure, he was added to the list for today, I'm not sure exactly what his.
Yeah. bond forfeiture hearing for today. He had bond up. He missed the hearing on April 15th, looks like. This was on an OBI, in this court, he had an OBI, case number 183525. Possession of controlled substance, 18-1234, and assault, 18-1233. He's on some sort of probation with common pleas or has bond with him. They asked for a urine screen, which he tested for a lot of stuff. Morphine, methamphetamine, ecstasy, fentanyl, cocaine. How do you want to proceed, Mr. Morford? Did you get a chance to talk with him?
Judge, I had, I'm really sort of hinged on right now, Judge, because I don't know what is going to happen. And
he's going to have to appear in common pleas.
Yeah, before I really begin to suggest or ask something to you, I think he needs to appear in common pleas. Although I understand he has a bond forfeiture in here.
There may be new charges coming on the police court, Your Honor. From what I understand, there may be tampering with evidence charges from a screen that has been submitted by him.
Well, what I want to do then, just to make sure things work, I'm going to continue this for a week. I'll keep him on the bond that he has with Mr. Sowers. And if somehow he gets released, he's got to be back here next Monday, the 20th, and Mr. Sowers is still on the bond to get him. I don't think he's going to get out. I think he's going to stay in jail. Hopefully we'll have appeared in common pleas before then. You're here next Monday, Mr. Morford?
Yes, Judge.
Okay. We'll be on the docket for next Monday, May 20th, 10 o'clock.
Thank you.
State of Ohio recalls Laura Nicola, case number CRB 24286.
Okay, we're letting the state do a background check on Ms. Nicola before we decide.
Would you like to have a copy, Judge?
Yes.
Your Honor, what I have learned from this is that we've lifted our lamp beside the golden door, or whatever it says in the poem on the Statue of Liberty. However, in this case, instead of New York Harbor, it's the Mexican border. And she's been removed twice as far as what these records indicate. As far as other criminal charges or anything of that nature, it looks like there was something in Virginia, but it doesn't look like it followed through. It looks like it was maybe dismissed.
Well, does the state have a recommendation to the court as to how to proceed with this information?
Did she enter a guilty plea?
She did.
Well, ordinarily, You know, we're going to recommend a suspended jail sentence and some community service, but, you know, under the circumstances, I don't think that since she's not a resident of this area, that it would be a practical matter to have her do community service or even be able to track that if she's going to be out of state. So we would just suggest a jail sentence of 3 days.
I can stay here. I can stay here for 1 month. Please, I have 3 kids, please. I can do community services.
Well, it looks like there's, and I don't really understand what this means, but June 2nd of 23, there was an alien removal under section 212 and 237.
Yeah.
And
In 2020 and 2023.
and one in November of 2020 also.
I take it as being removed as illegal entry into the country.
Is Mr. Steyer still here? Or?
He is no longer here, but Mr. Morford is.
Mr.
Morford.
Morford, okay, let's have him come in.
Excuse me, can I have the right to have an attorney, a lawyer?
That's him getting you a lawyer right now.
Thank you so much.
Mr. Morford, I'm going to appoint you to represent this lady, Laura Nicola. Here's the issue. She's pled guilty to shoplifting. She has a Virginia address as she was traveling through. She was stopped at the Walmart with a duffel bag full of $457.55 worth of children's apparel and clothes when she was allegedly picked up for shoplifting. She pled guilty. There's some question, I would request a criminal history if she's in the country legally. So before I deprive her of her liberty, I wanted to give her a chance to have counsel.
When I come in United States, I'm not illegal here. I have an immigration court on next year.
Can the state do some checking on that to see if there's some indication of whether she is here legally or has some? I mean, there's things in the record that seem to indicate that she is not here legally, but I don't know that for sure, and it's not a criminal charge filed before me. But it's important, I think, to consider. So I'm going to order her not to depart the courthouse. I'll let you talk with her and let the state try to do some additional checking, and then we'll come back.
May I have your file, Your Honor?
Yes, ma'am.
Thank you.
2035, so she has to stay here. Ms. Kim, can you ask Rob to see if we can get a hold of
State of Ohio versus Cameron Spitzer. Case number TRC 23-1161, A and B. Mr. McCaskey.
All right, this is Mr. McCown's case, Cameron Spitzer.
That's correct, Your Honor.
Yeah. Your Honor, we're going to have video.
Okay, so we need Mr. Major's assistance.
Your Honor, I'm gonna log off soon.
Okay, that's fine. Don't need that anyone during the week. Okay. All right, state ready to proceed,
Yes, Your Honor.
defense ready to proceed.
Yes, Your Honor.
Do we have your specific issue, is this a trial or is this a motion?
Your Honor, it's a motion to suppress based upon the data that they've given us on the toxilizer utilized at the post. I think we would withdraw our issues on that. We're ready to proceed, however, on the investigation arrest SFSTs. We have filed a motion in there.
So probable cause to stop?
Not to stop, Your Honor. It was a collision that was being investigated. So it would be the reasonable suspicion to do the SFSTs as well as the arrest, and therefore the test as a result of that arrest.
All right, Mr. Gill, you ready to proceed?
We are, Your Honor.
Are you first one?
Call Trooper Branham.
Trooper, you'll come up to the witness stand, I'll swear you in. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do. You may be seated.
Trooper, state your name and where you are employed.
Trooper Branham, Iron Post of the State Highway.
How long have you worked with the Highway Patrol?
8 years.
Are you here with the local Post 44?
Yes.
During all that time that you've worked for the State Highway Patrol, have you worked regularly as working on the road as a patrol officer?
Patrolling, yes, that's all I've ever done.
As part of your duties, have you regularly made OVI arrests during that period of time?
Yes.
Were you on duty on August the 25th, 2024 at 9:35 in the evening?
Yes.
And at that time, did you come into contact with Cameron Spitzer?
Yes.
Did that happen on State Route 775 near Milepost 2 in Union Township here in Lawrence County, Ohio?
Yes.
And would you be able to recognize Mr. Spitzer in the courtroom? And if you do, could you point him out, please?
Yes, he's right there in the blue shirt.
Dr. O'Shea pointed to the defendant.
So what caused you to come into contact with Mr. Spitzer on that day?
I was called to a single vehicle crash on State Route 775 near Milepost 2.
So when you arrived there, were you able to locate Mr. Spitzer?
Yes.
And I would just like for you to tell the court what happened upon your arrival there.
When I arrived on scene, I came out on the curb and observed it looked like a tree was down. I initially thought he had struck a tree. After I began my investigation, I observed that he had a utility pole. The lines were pulling the tree down, and I observed his truck way down the embankment up against another tree.
Did you get an opportunity to ask Mr. Spitzer what happened?
Yes.
What did he tell you happened?
He did appear confused that he was going uphill or downhill originally. He advised me that he was going around the curve, he downshifted, accelerated, and that's what set him off the road.
What kind of vehicle was he driving?
Ford Ranger.
So he downshifted, so was it a standard shift vehicle, do you know?
He downshifted to be a manual.
What did I say?
Standard.
Well, okay, manual.
Oh, yeah, sorry.
Now, taking that information from him, was there a curve there that would have required someone to downshift if they were driving within the speed limit?
Not necessarily downshift, no. You can take that curve at the posted speed limit of 55 miles an hour.
Now, that evening, was your patrol vehicle equipped with forward-facing camera on the dash, a back seat camera facing the back seat of your vehicle, and then were you wearing a body camera?
Yes.
Were all three of those operating at the time?
Yes.
Were those uploaded to this Axon system for use in this case? And were you able to review those before our hearing today?
Yes.
I'm going to stop this for a second. Is this a view from your camera as you approached where the crash occurred?
Yes.
And what I'd like for you to do, were you able to determine what curve that Mr. Spitzer was talking about negotiating when you had the crash?
As I approached the scene, yes.
When we see that on the video, could you indicate where we are?
Yeah. As you come around, it's going to come to the right, your curve, and it's going to come up, back around to your left. It's a second.
So is this right here, the curve that he said, downshift to go around?
Yes.
Would that indicate to you that there's traffic in excess of the safe speed?
The posted speed limit, yeah.
Now, is that video accurate as far as what you observed as you were approaching the scene of the crash at that point?
Yes.
Now, you've said that it looked like he hit a tree. Can you see the tree that he hit from there?
The tree he actually hit, you can't see from where I'm sitting right there. The tree I initially thought that he hit was when I came around the corner. I believe there was a fire truck sitting there. You can see the limbs that were pulled down. It looked like the tree had been knocked over.
From here, could you actually see his car from where you were sitting at this point?
I don't recall if I can see it from there.
But you could see the tree.
Right.
And it's often said that these video cameras are flawless, but it really doesn't pick up everything, does it?
Right. They have been improved, yes, but not everything.
When you spoke with Mr. Spitzer, and I want to go back to his explanation of what happened, you mentioned something about uphill. Was he able to tell you whether he thought he was going uphill or downhill at the time?
He seemed kind of confused if he was going uphill or downhill. I initially spoke with him, yes.
So which was he going?
He was going uphill.
And that would actually cause the car to slow down.
Right.
And I'm going to mark this as State's Exhibit 1. Phil, what is that document? Oh, this is a crash report. You need a copy of it. Thank you. I'm asking you what this is.
That's a crash report from the night.
And does it appear to be an accurate copy?
Yes.
Was there, in this crash, was there damage to anybody else's property?
Technically, yes, the utility pole owned by Frontier.
Did Mr. Spitzer have valid insurance?
Yes.
So were you able to, I know you're not a crash reconstructionist, but could you tell what happened in the crash? Can you let us know what exactly you saw?
So as I conducted my crash scene investigation, it appeared that the defendant came around the corner to make his left-hand curve. As he made that turn, he went left to center off the left side of the road, missed a mailbox that struck a utility pole, overturned down an embankment, and came to final rest up against a tree.
So as you were getting an explanation from Mr. Spitzer about what happened, did you make any observations about possible impairment as far as his personal appearance and the things that you were able to observe?
Based on his story, he appeared a little bit confused. As I spoke with him, I was able to detect an odor of an alcoholic beverage emitting from his breath.
I'm going to ask that State's Exhibit 1 be amended.
Mr. McCown,
No objection, Your Honor.
it's been marked.
Yeah, I'm back.
Okay.
Were you able to determine how old Mr. Spitzer was at the time?
Once I obtained his driver's license, I immediately observed that it was a what we call vertical facing license, not a horizontal license. After reviewing his date of birth, he was 18 years old.
Lift it up a little bit, and I'm not sure where on this.
Usually takes it pre-records 90 seconds before it activates.
some conservative, all right? Let him say it. Like that. All right, I'll be right back with you. Yeah, I looked at the one down there, it's just UPS order.
That's a photo cable line, I'm not sure if it's on from here. Or it is a local delivery. That's all we need. Running out here. That line's back up there. And that's the base and the line. I'm gonna go grab my camera, and then I'll grab a step before I break down too. You just missed that bell lock. That's why I went between the bell locks. Well, I thought I was coming down the hill. Just coming down, I thought I was coming down the hill. Okay. All right, same time, I'll even let you really remember what happened. Do you remember why you went up the road or anything? I remember coming either down or up the hill. Just I downshift and coming down the hill or up the hill. Just kind of, having some gas, start sideways, and that was all I remember. Okay.
During that last segment there, when you were speaking with him, did you determine that he was the one driving the vehicle?
Yes.
Now, given the clues that you'd already discussed, you've already testified to, speed, loss of control, and his incomplete recollection of what happened, the smell of alcohol, and maybe even his age, I don't know if that played a part. Did that play a part in your thinking also?
No, with him being 18 and smelling the odor of alcohol, he's under 21, so he's not allowed to be drinking.
By the way, did you ask him if he had anything to drink?
I believe I asked if he had any alcohol beverages. I asked him if anything to drink, and he said he didn't have anything to drink.
So at that point, had you made a decision to administer field sobriety test?
Based on what he's telling me what happened, being confused, not really recollecting what happened with the crash of the odor, yes.
Now, you're a state highway patrol officer, and you've been active for quite a while, correct? Correct. And you've received training on the proper way to administer standardized field sobriety tests according to NHTSA standards, which are what are used in the state of Ohio.
Correct.
Were you initially trained on the 2015 manual?
Yes, when I went through the academy in 2016, the 2015 manual was the most recent, so that's what we were trained on.
And after that, are you familiar with the 2018 manual?
Yes.
Were you ever trained on that or received any updates on that?
Each year we do an in-service training. Anytime there's any legal updates as far as any prior training we've had, they will retrain, I guess you can call it retrain, present that to us, yes.
If you don't get your training that's required, do they allow you to go out on the road?
No.
There's now a 2023 manual. Are you familiarized yourself with that too?
Yes.
So you're able to administer the standardized field sobriety tests in accordance with NHTSA standards?
Yes.
I'm going to show you, previous to this hearing, I gave you copies from the various NHTSA manuals and asked you to compare these copies with the manuals themselves to make sure that they're accurate copies. Have you done that?
Yes.
And I'd like for you to look at what I've had marked as States Exhibit 2 and ask you if those are accurate copies from the 2015 manual.
Yes.
And likewise with the 2018 manual, it's marked as Exhibit 3, I'd ask if you are familiarized with those copies and if they are accurate copies from the manual.
Yes.
Mark, do you need to see these?
If I could see what sections and pages.
And also,
Yes, please.
I'm going to show you Exhibit 4, which is, I'm going to ask you, those are accurate copies from the 2023 manual.
Yes.
So, field sobriety tests, are those designed to give you further evidence of possible impairment?
Yes.
I believe in this case that you started maybe asking some questions, but then you went and started doing the crash investigation. Is that
As far as his witness statement or his...
as far as, well, who's going to play it forward here for those seconds? So you asked him some more questions, and you started, and did a, I guess, a preliminary horizontal gaze nystagmus.
I was just checking to see if he had horizontal gaze nystagmus. That one, yes.
So that wasn't necessarily the beginning of formally doing the field sobriety test. So you actually, from here forward for a few minutes, you are taking pictures for the crash report, maybe taking some measurements and things of that nature.
Correct.
Mark, I want to go ahead and just forward this after he finishes the crash report part of it, if that's just to let you know.
Sure. What's this timestamp there, Mr. Hill?
Pardon?
The timestamp that you're stopping and then skipping forward to?
8:30.
Okay.
I'm going to go forward to 23:39.
Anything on the road, like a deer or anything like that? Do you know how fast you're going?
Okay, I want to ask you some questions before we go into this. Did you ask him some preliminary questions, first of all, to find out whether he was physically able to perform standardized field sobriety tests? And what kind of things did you ask him?
I asked him if he had any recent head or eye injuries, if he was on any medication to medications, if he had any contacts or glasses, he was supposed to wear.
And did you also ask him questions about the crash itself as part of your investigation?
Yes.
And is that part of the crash report?
I think you did it.
Trash reports over here. Let's interrupt this hearing. I'm going to let Mr. Morgan come back if he's available. We're getting in here. We can finish up this one case while you can say we're done. Mr. Morgan.
State of Ohio versus Laura Nicola, recall case number CRB 24286.
Just got the phone call from immigration. She's on the phone.
I got your text, but I don't really understand that.
May we approach, Judge?
Yes.
She has a immigration case pending, which is the information I mentioned. I called that court, and she is not here, in court until February 25th of next year. I can't tell you how she's even here. The clerk couldn't give me very much information.
How do you want to?
Well, I don't know. Apparently Missy's on the phone with immigration right now. Asylum is a very narrow definition. Your life's in danger because of some political or some war or something like that. And I don't think we're in a war or any kind of people remaining right now. That's where she was born. So, but I don't, obviously that's outside the scope of the school. I just think she's caught shoplifting $400 something.
Was there another person with her?
A minor, out charge. So, I mean, I think it's appropriate for her to be executed.
She's a woman, she needs to get me to reach her.
You want to wait for what Missy's coming out?
I'm not going to be
Okay. That'll be okay, so.
Yes, yes.
Okay. All right, well, I think we're not quite ready. I thought maybe we'd be ready to finish this, but we're going to let the prosecutor's office continue to do some research and then we'll recall it.
Thank you, Your Honor.
All
right, you can proceed, Mr. Hill.
Thank you, Your Honor. So I've shown you again the crash report, it's already been in the evidence. And about the last time, a written narrative of the conversation with Mr. Spitzer. Is that what you found out from him about his explanation as to how the crash happened? Yes. And does he admit to excessive speed in that?
When I asked him how the crash prevented, his answer was normal rate of speed.
Any recent hit or eye injuries? Do you wear contacts or glasses? You take any medications? Any alcoholic beverages tonight? What was your last alcoholic drink? Last week. I got the crash of the
I downshifted and accelerated. I probably could have avoided doing that. Say it more great speed, stay at more speed.
What's the phone number for you?
606-971-2194.
So what I did was continue on to the second page. I can sign this first one there. You could sign the second page in the same spot. Okay? If you need to sit on with it, fine. Thank you. You say you don't take any medications or anything like that? Do you have any weapons on or anything? Like no pocket up here if I face down? Good. I'm just gonna look, there's just a camera here, so you could face that way for me. Just put your hands here on the small of your back. It just reminds me, it doesn't go poke me, stick me, anything like that. Take your phone. Yeah. Are the keys still on the truck? Okay. Alright, go ahead and sit down here on this little board right there for me. Alright, turn and face me this way. You said you had any alcohol in there? Yes, sir. Okay. Just the reason I'm asking, I get the smell of alcohol beverage coming from your breath, okay? Next what I'm gonna do is just start to make sure you're okay to drive. As long as you're okay to drive, you're just gonna be side security control, you have. Any questions?
Doesn't downshifting generally make a vehicle slow down?
Yes.
And accelerating and downshifting would not be something that would normally be done in order to maintain control of the vehicle.
I don't believe so.
At this point, did you perform the horizontal gaze, or did you administer the horizontal gaze nystagmus?
Yes.
And why, first of all, tell me what horizontal gaze nystagmus is.
I'm looking for the involuntary jerking of the eye while moving the stimulus in a horizontal manner.
And why is that important or relevant to a discussion about whether someone is impaired?
Based on the NHTSA manual, that's the most reliable test to determine if somebody's impaired.
I would like for you to go step by step and explain how you administer that test and demonstrate as you're doing it.
Okay. So here, 775 is a pretty graded road. This driveway is also graded, but at the bottom of it, it levels out. He is a little bit taller than me, so I had him stand on the level part of the road, or the driveway. I stood on the slope part of it. It was easier for me to see his eye. I always use my pen, one of these two pens. I have them at the tip of the stimulus here. I placed him in front of me. I had them put their hands underneath their chin like this. Just the way I was trained during my FTO as far as officer safety, I can always see their hands. We were trained our hands will kill you. Heaven forbid if I miss something during the pat down. Once I start, I stick my pen out, make sure you can look at it here. I'm checking for equal pupil size, resting nystagmus. And I start the equal tracking by moving to his left and my right on a kind of 1, 2, 1, 2 back to the middle. Once you get back to this side, to my left, it's a count from 4 back to the middle. You pass through twice, and you come to the middle and have a distinct stop before I start like a smooth pursuit. Come here, stop for a second. Begin, do the like a smooth pursuit. 1, 2, 1, 2, 3, 4. 1, 2, 3, 4. And 1, 2, 3, 4 back to this side. And then come back to the middle. I always pause for a second again. And then I start the next one. Distinct nystagmus at maximum deviation. So I move out to maximum deviation. You're not looking for, there's no white in the corner of their eye. Hold it there for a minimum of 4 seconds. I always count to 6 to make sure I hit the 4 seconds. I then bring it back to the other side. Same thing, minimum of 4 seconds. I always count till 6. Check his left eye again, my right, and his right eye again. Come back into the middle. And then you are checking for onset nystagmus prior to 45. So I'm going up to a 45-degree angle from his line of vision. You count along Mississippi, you can't get out to that 45 degrees any sooner than 4 seconds. As I go out there, I observe that he does have onset. As I get out here, close to the 45, pause, verify it. Same thing back on the other side. Count as I'm going, verify it, check his eye, his left eye again, his right eye again, and then I come back to the middle, and then test is complete. 4 mile case is complete.
Now, in this case, and also, do you provide instructions to the person who's subjected to the test in order for them to understand what is expected of them?
Yes, I ask them to look at my stimulus with their eyes and eyes only. I move my stimulus or my pen back and forth and then follow with their eyes and their eyes only.
Did you do that in this case? Now, one of the instructions, I believe, according to the NHTSA manual, is that you tell them to keep their hands down at their sides. Although you had him put his hands up under his chin. Is that something that you are instructed to do that may be a little bit different from the strict NHTSA standards?
During my FTO phase, that's how my coach trained me. Like I said earlier, our biggest thing is to watch somebody's hands because their hands will kill you. If you're not watching their hands, looking off at them, they can pull out a weapon before you know it, your staff. So I always had them put it underneath their chins underneath their chin so I can observe their hands while I'm observing the test.
In this case, how many clues did you observe?
6 of 6 possible clues.
I'm going to show you what I've marked as State's Exhibit 5 and ask you what that document is.
This is my impaired driver report.
From an
OBI crash.
In this case?
Yes.
And does it indicate 6 of 6 clues?
Yes.
And I think you might have said this before, but just to make sure, according to NHTSA standards, if a person has at least 4 clues, what is the percentage likelihood that their breath alcohol will be at least 0.08?
88%.
I believe during this, you might have also checked for vertical gaze by nystagmus, is that correct?
Correct.
And in this case, did you observe any vertical gaze by nystagmus?
I did not.
What is that test used for?
We use that test to determine if the amount of alcohol that subject has consumed is a high dose for that person. If it is a high dose for that individual, when we check for vertical gaze nystagmus, it will be present.
You could put your hand underneath your chin like this for me. All right, you're a little bit tall, honey, so you could take one step this way for me. I'm used to this is good my advantage. Now watch the tip of my head right here for me. You're gonna watch it with your eyes only. We'll go back and forth. Just watch it with your eyes and eyes only for me. And keep your head in there.
begin to the preliminary stage of determining whether he can perform the walk and turn test?
Yes.
And what kinds of things are you going to ask him where he's going to cut it off in the middle of the question?
If he has any type of medical conditions, that's going to affect his balance, his knees, back, ankles, anything along those lines.
Did he determine that he had anything that would keep him from being able to take that test?
No.
So the walk and turn test, I would like for you to explain how that test is conducted. Beginning with the initial instruction, the demonstration, and then how you expect him to perform and what clues you want.
Somebody get through how I administered the test. That was the next one.
I'm sorry.
Explain how I administered the test. Is that what you're asking?
Yes.
Okay. So here on this driveway, there's no painted lines. I'm not going to ask him to walk down the crack between the concrete. Might throw him off balance. So we go down a little bit closer to the garage there, in the video be to the right, farther away from the vehicle. I ask him an imaginary straight line going from him towards the vehicle in front of him. And then ask him to put his left foot first on this imaginary straight line, and then his right foot touching heel and toe in front of him. I had to ask him to restart that part of it because he had his feet backwards. He had his right foot on the line and his left foot in front. So I had him back off the line and then get in the starting position. And once I have them in that starting position, I have to put their hands out of their side and I instruct them to stay in that position until I instruct them to begin the test. I then explain the test. He's going to take 9 toe steps down this imaginary straight line towards the vehicle in front of him. When he gets to his 9th and final step, he can leave his front foot on the ground, make a series of small steps, and do 19 toe steps back. During the test, he's going to look at his feet, count his number of steps out loud, keep his hands at his side, and once he starts the test, do not stop. I ask him if he has any questions, and I ask him if he understood the test. If he did not have questions, and he stated that he understood the test.
And what, if any, clues of impairment did you observe?
That he moved his feet during the instruction portion of the test, and then when he goes to do his turn, he lifts up his pivot foot that's supposed to remain on the ground to turn himself around and go back to the other way.
And I'm going to show you, again, what I've marked as states Exhibit 5 and ask you if you can record those results on here. Right.
Consider knees, back, ankles, anything, nothing's gonna affect your balance or anything like that, or gonna like vertigo or anything like that? Okay, are you able to do like a walking turn and stand on one leg, just kind of test? Okay, we're not gonna use this because it's so fine, this is a flat part, property I found out here. Alright, I want to start with this, flashlight is there for you. We're gonna pretend there's a straight line going from you, actually take a step back to that, right before that, right there you go. We're going to pretend there's a straight line going from you straight out towards that vehicle, okay? So go ahead and put your left foot on the line like this. Your left foot, and your right. Now, switch your feet. Alright, start over. Yeah, right. Alright, so this is the start of your line. Put your left foot on it like this. Put your right foot on it like this, touching heel to toe. Put your hands at your side. Down your side. You gotta say it like that until I instruct you again, okay? When I ask you to, you're going to take 9 toe steps down this imaginary straight line. When you get your 9th and final step, you're going to leave your front foot on the ground, make a series of small steps, do 9 toe steps back, okay? Starting from here? Starting from here. I'm going to demonstrate for you, then I have you do it, okay? Your first step from this position is going to be 1, okay? 1, 2, 3, all the way to 9. This is your 9th and final step. You're going to leave this front foot on the ground, make a series of small steps, turn yourself around 180. 1, 2, 3, all the way back, okay? During the test, you're going to look at your feet, count your number of steps up loud, keep your hands at your side, and once you start, do not stop. Okay? Any questions? No, sir. You understand what I'm asking you to do? All right, go ahead and begin when you're ready, okay?
likely, but that an individual has at least a .08 breath alcohol score if they have at least 2 clues of impairment on the long term.
79%.
Now, did you move on to the one-leg stand test after that?
Yes.
And I would like for you to explain how that test is administered and what instructions you give.
Okay, so I have them stand, put their feet together, hands at the side. I instruct them to stay in that position until I tell them to begin the test. I explain to them whichever foot's more comfortable for you. You can lift approximately 6 inches off the ground. You leave your foot parallel to the ground, count out loud, 1,001, 1,002, 1,003, so on and so forth. You keep counting like that until I tell you to stop. During the test, you're going to lift the tip of your foot, keep your hand at your side, and count out loud. I then demonstrate the test. I explain to them I'm going to use my right foot. You can use whichever foot you'd like. I demonstrate the test for him. Count to 3. Make sure he sees how my foot is parallel to the ground, both my legs are locked out. I ask him if he has any questions. If he understood the test, he did not have any questions, he understood the test. And then I instructed him to begin.
And what clues did you observe on the one-leg stand test?
There was a slight sway while he balanced. A very small portion of it.
That was the only clue you
That was the only clue I observed, yes.
I'm going to ask the State's Exhibit 5.
Any objection?
Your Honor, I would like to cross-examine. That's the impaired driver report?
Yes.
I would like to cross-examine first, please.
Okay. Be reserved.
Spot, okay? Put your feet side by side like this for me, hands at your side like this. Say it like that till I tell you to begin, okay? When I ask you to, whichever foot's more comfortable for you, you're going to lift approximately 6 inches off the ground. You leave your foot parallel to the ground, count loud, 1,001, 1,002, 1,003, so on and so forth, okay? I'm going to use my right foot for the demonstration. You can use whichever foot you like, okay? 1,001, 1,002, 1,003, okay? See, my foot's parallel, both my legs are locked out. You can keep your feet like that for me, okay? During the test, look at the tip of your foot. Keep your hands at your side. Keep counting out loud, 1,001, 1,002, 1,003, so on and so forth. Keep counting like that until I instruct you to stop. It's going to be a time test, okay? Do you have any questions? Do you understand what I'm asking you to do? You know what foot you're going to use?
I'll turn over to my right.
Okay. Go ahead and begin when you're ready, okay?
1,001, 1,002.
Look at your foot.
2003, 2004, 2005, 2006, 2007, 2008, 2009, 2010, 2011, 2012, 2013, 2013, 14, 2015, 2016,
Your foot apart.
2017, 2018, 2019.
All right, go put your foot down, okay? All right, we're going to walk over here to the front of my car, okay? You know what the legal limit for 18 years old?
I'm not sure what that is.
What under 21 is?
I'm not sure what that is.
Okay, it's only 0.02, okay?
Now, was the surface that those two, the walk and turn and one-leg stand, was that a flat surface?
Yes.
Were all of the standardized field sobriety tests that you've done in substantial compliance with NHTSA standards?
Yes.
Based on everything that you observed and everything you heard from Mr. Spitzer from the time that you first had interaction with him up to this point, did you determine that he would be placed under arrest for OVI and failure to control?
Yes.
Is all the video that we've observed, we've watched here in the courtroom, does it accurately reflect what happened, fair and accurate representation
Yes.
of what happened? Mark, you say you're waiving the argument forward on the breath testing?
On the one done at the post, not the PPT.
Yes.
So-
Well, no, I understand that. But
Yeah.
I don't have to get into all that with the post and all that. I'm going to ask that the video be admitted, and I believe that might be number 6. Melissa, do you need it?
I've got one.
That's all I have, Your Honor.
All right, I'm gonna take a break. I've been sitting here since 9:30, so I'm gonna take a break and then we'll come back to this. Or we recess.
So I'm going to sign for a minute. Yeah, sure.
Redirect, maybe. I don't know.
That's what we're here for. For a long night.
We'll be here till 9 o'clock. I know, big well, I've been here since 7:15. You know what? I was watching that. I'll never pass that. I'm 76 years old. But I don't drink anyway.
Pretty high from, things considered.
He's going to do his argument. Certainly.
I know that kid, I know his dad. They're twins, he's got a twin brother.
You know, we're not hungry anymore. At 18 years old, they ought to be able to do the fields run test.
Yes.
Oh,
yeah.
He agreed because of our side, he said, "We're going to do a jury trial." I played the video with the post treatments on this jury.
Well, for some trial.
Yeah. I told him, I said I could never pass that.
Oh, I can't either.
I couldn't do it, not at my age. And I don't think.
I've been to the bathroom
if I
15
drunk,
times.
He's still good with, God, damn, he's.
Huh? Let me tell you something. He's driving.
Are you okay with bumping into
Yeah.
We've already started now.
Oh, so now it's changed. Okay, I'm
I gotta
good.
waste my time up there.
It's, I'm good.
On your tab. So you became a doctor. I live up on Silver Drive, if you know where that's.
Okay.
It used to be Old Belgium. It's past the 411, you go through the stop sign. It's before you go up Big Patty.
Okay, yeah.
I used to live on Big Patty. I built me a new house. Yeah. I tell you, I see so many people. Is it the three-way stop?
Yeah, nobody stopped there. I've stopped some, because I just lived down off the hill. I've stopped several people.
Oh,
They
yeah.
don't come and,
We've watched all.
depends what way they're going. They won't see me as I'm coming down 411. And I'm like, you gotta stop. I didn't stop. No.
Well, they were, I have a
Yeah.
some guy come out of me in the lane and just almost tipped me over. Just barely did. Where now? No, they don't pay attention.
Yeah, I tried to tell John to look at the camera. How my investigation work?
I'll be right back. I'll go back.
We'll wait on you, Mark.
Okay. I'll be back.
Well, if you think of it, you tell him to learn to full road treatment, which you might already know.
I saw her on 411. I knew that was her.
Yeah, and then Jeremy paid off all his funds in West Virginia. It was $770.
Hey, Missy. Darlene Green's in intensive care.
She is.
She's got blood clots.
Oh, no.
Yeah. I guess she fell a few times or something. And
They took her to the hospital who was telling me that? Paul.
Luke Holmes.
David Aggins, that goes to church with them, said their pastor put on their message or something to keep her in prayer.
Oh my goodness, that's terrible. I love her.
Oh, yeah.
They don't come any better than Darlene.
Lou would be devastated too if something would happen to her.
I'm sure.
Yeah, because
Yeah.
Lou depends on her for everything.
Everything. She's the wheel that keeps it going.
Yeah.
She keeps everything going, including Proctorville.
Yeah. Nobody else would put that time in like that.
No. Wow. I hate that. Well, hopefully she snaps out of it.
Yeah, hopefully they, can give her medicine and stuff.
Yeah.
Yeah, they'll put them, if they give them like heparin, they'll put them in ICU just because of that.
Lou won't answer his cell phone.
You probably can't hear it.
You gotta call the home phone and leave a message if you want Lou to call you back.
Oh my goodness. But he answers if the judge calls. I
Uh,
bet he'll answer it if the judge calls.
probably.
Yeah.
All right, I guess we'll take off. Linda Fuller and Jeremy McMillan. I'm grabbing him for paying off those funds.
Lawrence County Municipal Court is now back in session.
Okay, we'll restart the cross-examination of the trooper.
I think my client's in the restroom, Your Honor.
Okay. And we don't have a trooper. All right, trooper, you're still under oath. Mr. McCown, you're cross-examined.
Thank you, Your Honor. A couple of questions. First, have you ever owned a vehicle with a steam transmission?
No.
Have you ever operated a vehicle with a steam transmission?
Yes.
Okay. You would agree that if you are proceeding up a hill and your speed begins to drop, to accelerate, what are you going to do effectively?
Using downshift.
You're going to downshift. So when you testified earlier, hey, it's not normal to downshift to increase speed, there are actually circumstances where that, yes, you do downshift to increase speed. Is that correct?
To maintain speed.
You would agree
You can downshift, yes, to accelerate.
Okay.
Sorry.
And you would agree that you found here that he was actually going uphill. Is that correct?
Yes.
And in fact, you said he was confused and a little bit disoriented. Is that correct? I believe on State's Exhibit 1, the traffic crash report, it looks like from your diagramming of it that the vehicle rolled from the way you had it diagrammed.
Yes.
Do you believe that the vehicle rolled?
I do, yes.
Okay. So, in your opinion, and how many crashes have you investigated over the years?
Probably close to over 1,000 maybe. I'd say.
Okay. How many rollovers?
I wouldn't say off the top of my head.
And how many of those rollovers did the driver appear disoriented afterwards?
I don't recall.
Would you say that it's common in a rollover incident?
I wouldn't say it's common, it can happen.
Okay. And additionally, with horizontal gaze nystagmus, there are multiple things that can cause nystagmus, is that right?
Correct, yes.
Including a head injury, such as a concussion. Is that correct?
Yes.
Which could occur in a rollover incident, is that correct?
Yeah, it could, yes.
Now, you indicated that in your report that all you had was an odor of alcohol that would indicate impairment originally coming from him. Is that correct?
Yes, when I first spoke with him, yes.
Okay. And was there anything else other than the odor of alcohol that would indicate impairment?
The way he described The way he described how the crash happened to me didn't make sense.
So the disorientation of, I thought I was coming this way, I'm not sure.
Yeah.
With the horizontal gaze nystagmus, and by the way, when you were trained on these, to successfully complete your training and be approved to give standardized field sobriety tests, you had to perform them on an individual in a training situation in front of a scoring officer. Is that correct?
Yes.
You had to do it 100% correctly.
Yes.
If you missed one clue, if you missed, oops, I didn't tell him to do this, you were failed and had to repeat it. Is that correct?
Yes.
Okay. When you give the horizontal gaze nystagmus,
Watch with my eyes open. We're going to use this to my advantage. Watch the tip of my head right here.
by the way, you see well, we'll come back to that.
For me. Now watch
You've
with
got
your
him
eyes open.
looking at your pen.
Go back and forth.
Yes.
Watch with your eyes open for me. And keep your heads in the entire time. Okay.
Did she tell him to stay
Grease
focused?
the head around your grease.
No, sir. I told him to watch the pen and with his eyes and eyes on.
Okay, did she tell him to follow up for the entirety of the test?
I believe so.
Okay, you agree that if somebody doesn't follow for the test, if their eyes leave it, that's going to change the parameters. It's going to change how you view it, how they perform on it. Is that correct?
Yes.
You did not instruct him to do that.
I did not tell him to follow the entirety of the test. No.
That's part of your training, is that correct?
I believe so.
You are required to instruct them to follow it for the entirety of the test.
Yes.
The word contact glasses.
And so here, this is just this isn't, I'm going to say, it's not technically part of the test. This is where you're checking for equal track.
The pre-test.
The pre-test where you're checking for, make sure they're following together, doing all those
Right,
things.
equal people's.
Okay. Then you come back, and this is your distinctive pause. And it's supposed to be 2 seconds out, 2 seconds in. When you give it, are you bladed or are you square to the defendant in this situation?
This one, I don't believe I was fully bladed. I think I was more halfway bladed, I guess you could say.
Kind of like this?
From my understanding.
Sure.
So if he's facing it this way, I try to stand like this. I believe for this test, I was more like this, I'd say 45 degrees different.
Okay, which is going to kind of alter how you do that, is that correct?
As far as my, yes,
Your reach.
reach.
You would agree that when correctly done, if you're in a bladed position, you can go along that horizontal plane the entirety of it. Is that correct?
Yes.
You're supposed to do that test on the horizontal plane, is that correct?
Correct.
So that you don't swing and arc your arm. Is that correct?
Correct, yes.
So this is the first pass, equal tracking, or excuse me, smooth pursuit, is that correct? And then you went, how many times did you do smooth pursuit?
I did the eagle tracking twice and smooth pursuit twice.
Sorry, let me go back.
Just think it's after fair control, yeah. Okay. Any questions? No, sir. Okay. You could put your hands underneath your chin like this for me. All right, you're a little bit tall now, so you could take one step this way for me. I'm going to use this to my advantage. Watch the tip of my pen right here for me. Now watch it with your eyes only. We'll go back and forth. Just watch with your eyes only for me. Okay, keep your heads in the entire time. Okay. No reason to head around your grease. No, sir. The word contact.
Tell me when you begin the first pass, if you would, okay?
This is elective, or this is equal tracking.
Okay, tell me when lack of smooth pursuit begins.
Okay.
Okay? You need to rewind, or you're going to go from here. Okay, so it's your distinct or sustain the status?
From my video.
Now, so I'm going to ask you here, so you're doing your final pass on maximum deviation. So let's get into the 45 degrees. You agree, as you indicated, it's supposed to be on a time of 4 seconds to 45 degrees. What are you trying to do if you see Ms. Agnes?
Stop and verify.
Stop and verify, and that's the point of onset, is that correct?
Correct.
And then you are done with that side, you go to the next one, is that correct?
Correct.
That 4 second out to 45 degrees is supposed to be smooth, is that correct?
Correct.
Obviously, if it's not smooth, you're not going to be able to judge the eyes, is that correct?
Correct.
Okay, so this is going to be your first pass on 45 degrees. You stop here, and then go out again, and stop, and go out again, and stop, and go out again, and stop. You would agree that's not smooth?
Smooth now.
Okay? You wouldn't, if you're a attorney officer, you wouldn't pass an officer doing an onset of 45 like that. Is that correct?
Correct.
You can't see the other side. It looks like it stops right there. Your hand up in the corner and then continues on. Is that correct? Up here. And again, you stop and move. And stop. And it's jerky and it's not smooth. You would agree with that? Okay. You would agree that does not comport with the method in which you were trained and told to do. Is that correct? You're also trained in vertical gaze and nystagmus to do it twice, is that correct? Did you do it twice here?
I need to do it twice, yes.
Well, you're left hand. Do you have any type of medical conditions that are need back and nothing's gonna affect your mouth or anything like that? Not like vertigo or anything like that? Okay. Are you able to do like a walking turn and stand on one leg? Those kind of things? Okay.
Now, you testified to Mr. Gill that this particular video fairly and accurately depicts everything that occurred. Is that correct?
We're not gonna use this because it's inclined, right? This is the flat part, property I found out here.
Incidentally, you've got all these strokes back here. You can see yours in the back here. Is that correct?
Yes, yeah.
Okay. That's the direction he was facing when he did the horizontal gaze and nystagmus. Is that correct?
Yes.
So this is his viewpoint when he's performing the horizontal gaze and nystagmus.
Yes.
Alright, I want to start with this. Flashlight is there for me. We're going to do a straight line going from you. Actually, take a step back to that right foot. Right there. We're going to pretend there's a straight line going from you straight out towards that vehicle, okay? So go ahead and put your left foot on the line like this.
Okay, now I want you, if you would tell me where, you said he moves during the instruction phase. You should tell me on this video where he moves.
Start over.
It's gotta be when I'm demonstrating.
This is the start of your line. Put your left foot on like this.
When I turn to
Put
start
your right
my
foot on like this.
back.
You can feel the toe.
I think it's on my, to start my second side when you move.
Down your side.
My
Okay.
You sound like that too much.
You now placed him.
What they ask you to do is
Now let's start scoring.
straight line. You get your ninth and final step, you can leave your front foot on the ground, make a series of small steps, do 9 good toe steps back, okay? Starting from here? Starting from here. I'm going to demonstrate for you, then I have you do it, okay? Your first step from this position.
By the way, what's he wearing?
Jeans, green, shirt and boots.
Wearing big, heavy boots, right? What are you supposed to do to somebody with boots? What are you supposed to instruct them? On the one-leg stand and walk and turn. If they have boots or high heels or flip-flops on.
They want to take them on.
Yeah. You're supposed to give them that option, is that correct? Because certainly if you've got 15-pound engineering boots on, that's going to change how you do a walk and turn where you're supposed to line it up correctly, swing around, and it's also going to affect your ability to hold it up. Is that correct?
Can, yes.
Did you ask him if he wanted to take his boots off?
I did not.
It's going to be 1, okay? 1, 2, 3, all the way to 9. This is your 9th and final step. You're going to leave this front foot on the ground. Make a series of small steps from yourself.
Okay, so your position is this already happened, is that correct? He's already
Yes,
moved?
once I turn, my camera's gonna be facing them.
Around 180.
As I'm taking this step, I
2, 3,
or not
all the way back.
falls.
So that's asking you to look at your.
Okay, because you didn't say anything like, "Ooh, you okay?" or anything. There's no audible indications that he's done anything wrong. You would agree with that?
Feet record number steps out loud. Keep your hands at your side, and once you start, do not stop. Any questions? You understand what I'm asking you to do? All right, go ahead and begin when you're ready, okay?
Now, tell me where you stepped off the line again?
Look at your feet.
He doesn't step off the line.
He does not step
Look
off.
at your feet.
Okay. You said he turned improper.
Yeah, his plant foot is, he picks his foot up as he's turning around.
Because, so you're saying he got to there and went like this?
And picks his,
So when he gets to there, you're saying when he turns around, he picks it up, rather than spinning on his boot? And his boots, rather than spinning on that foot?
Yes.
Okay.
Say it like that till the begin, okay? When I ask you to, whichever foot's more comfortable for you, you go with approximate.
Did he ever slur, by the way, in his speech to you?
no.
What are the indicators of, I think when the breath test was .142?
Yes.
You're taught that they're and trained that there are certain ways that people act at various alcohol concentrations, is that correct?
Yes.
What would those be at, say, .14?
Depends on the person's tolerance. They can be as good as doing any test I ask them to do, or they can be unable to maintain their balance, can't stand up straight. All that kind of depends on.
You're trained that the typical effects of alcohol at .10 are clear deterioration of reaction time and control, slurred speech, poor coordination, slow thinking. Is that correct?
Yes.
And at .15, which is basic, almost where he was, far less muscle control than normal, vomiting may occur, and significant loss of balance. Is that correct?
Yes.
Did he exhibit any of that on here?
No.
Any of the things I talked about there?
No.
Even the .10?
No.
At .08, muscle coordination becomes poor, balanced speech, all of those. Did he exhibit any of that?
No.
Only 6 inches off the ground.
I'm going to ask you, you indicated that he exhibited one clue. One leg steam, is that correct?
Yes.
What was that one clue?
He's slightly swayed, excuse me.
Sway, okay? I'm going to ask that you point that out, if you would, please.
Flat to the ground, count loud, 1001, 1002, 1003, so on and so forth, okay? I'm gonna use my right foot for the demonstration. You can use whichever foot you like, okay? 1001, 1002, 1003, okay? See if my foot's parallel, both my legs are locked out. You can keep your feet like that for me, okay? Third of the test, look at the tip of your foot. Keep your hands at your side. Keep counting out loud, 1001, 1002, 1003, so on and so forth. Keep counting like that until I show you stop. It's gonna be a time test, okay? Do you have any questions? You understand what I'm asking you to do? You know what foot you're going to use?
I think I'll do all right.
Okay. Go ahead and begin when you're ready, okay?
1001, 1002,
Look at your foot.
1003, 1004,
I'm sorry, that already happened?
1007.
When I come look down at his foot,
Okay.
he shifts.
Is that also when you shift, because it looks like the key
Look at your
changes.
foot.
Right there.
Right there, that.
1005,
Your testimony is that is a sway.
Yes.
That is a clue that somebody's not. Matter of fact, under NHTSA's guidelines, they specifically state that individuals can do it only for 25 seconds, but they can't maintain that 1 foot balance for 30 seconds. Is that correct? Does he sway at any other point in that day?
After that,
All right, go fix
So
your
you're that one little tiny shoulder pitch to the left. Your position is that indicated that he was intoxicated.
that's a clue, yes.
The impaired driver report, as well as the traffic crash report. This occurred around 10, I think, 10:30, that you were out there.
I was out there, yeah.
Would you have been on midnight, or would you have been on evening going over, leading over?
It was the end of my shift, yes.
Okay. I presume you didn't go back to the station and sit there and write reports for an hour and a half on all of these?
No, not that night, no.
Okay. Do you know what you work the next day?
I think it would have been another 2 to 10 shift.
Okay. Did you do the reports that day, or did you do it at a different point?
I believe I did it the next day, my next working day.
Do you typically do them your next working day, or is it just whenever you can based upon the limitations of personnel?
I usually try to get them done as soon as I can, because I don't know what my day's gonna look like.
Okay. So when you went in the next day to do these reports, you would agree, by the way, then, of course, these reports were not done contemporaneously with the investigation. Is that correct?
Correct.
Okay. Did you take field notes?
No.
So you didn't mark down, hey, he's waiting here, he did this, any of that?
No.
How do you go about at a next shift, or whether it be that day or 2 days later, going back and obtaining the information and recollection to prepare these reports?
As I do the report, I type it out from my observation memory, everything I remember from the scene, and then I go back and watch my video to make sure it matches what I.
Okay, so do you do it, are you watching the video while you're doing it? Let me ask you that. No, your testimony is you always type out your report first, and then watch the video to verify that what you did was correct.
Correct.
What happens if you're wrong in a narrative?
As far as if I'm.
If you misremember, sure. If you go back, you look at the video and go, ooh, that doesn't match what I typed up here on my recollection. What do you do?
It's what I typed in there. I can't go back and say, well, I mean, you could erase it, but like I said, I type it on memory and go back and make sure it matches. I don't erase anything out of my report once it's typed, basically, unless there's like a grammatical error.
Well, so why watch the video to see if you're right, if you're just doing it from memory?
Just to make sure it matches. I don't want to. So when I'm putting in here, I want to basically to make sure it matches what the video says.
Sure.
Right.
So I understand. That's you're wanting to make sure that they match up. Is that correct?
Right.
So if there's an error in what you typed up, you're going to, well, the video says this. I guess that's what it was. I was wrong, and you're going to correct it according to the video at that time. Is that correct?
Yeah.
Okay. So while initially you're typing out of the notes of the event would be from memory, you're going to go back and pick up if you missed anything in your memory or do whatever, you're going to do that from the video. Is that correct?
If it's something I missed, like a clue, if I didn't see it on the scene there, I'm not going to go on my video and basically say, yes, this happened, but I didn't see it.
Okay. Did you do the reports at the same time, the impaired driver report and the crash report?
Not as far as working on it at the same time. I believe I did the OVI statement first and then the crash. Either one, I don't remember which order I did them in, but I did one report, complete it, start the other report.
Okay, so there was no time difference, is what I'm
No, I sat there and got everything done.
You did all in one sitting,
Yes.
basically. You didn't do one, go out on patrol for a while, come back, and then do
No.
Again, he never slurred his words, never had bloodshot eyes.
Correct.
Now, he indicated that, I think Mr. Hill classified it as, hey, he based it on this excessive rate of speed. There's been no testimony that he was flying. I mean, it was just in excess of the conditions, or 1 mile, technically 1 mile over would be an excessive rate of speed. Is that correct?
Excessive the speed limit, yes.
So if he were doing, what was the speed limit out here?
55.
So if he was doing 56, that would have been an excessive rate of speed.
It would be an excess. I won't call it excessive. It would be an excess of the speed.
Okay. In your experience, is speed in excess of the speed limit an indicator of impairment?
It can be, yes.
It can be, okay? Certainly if you're being reckless, if you're doing 110 miles an hour, that may show a lack of judgment. If you're getting 1 mile over, does that show a lack of judgment to where they're impaired?
Not necessarily, no.
let me put it this way, how many speeding tickets have you written in your career?
Probably a couple thousand.
Okay. How many of those were intoxicated?
A handful of them, I don't know exactly.
Okay, so a handful versus a couple thousand. So you would agree that a couple thousand people would not be indicative that they were, hey, just because they were speeding doesn't mean they were impaired. Is that correct? You're in the commercial sector now, is that right? Are you doing truckers and all that stuff?
LCS, yes.
Okay. One of the most important things also that you look at when you talk to them, you look at their logbooks and all that stuff. Is that
Yes.
correct? Why? What are you looking for?
Hours of, make sure they're in compliance with the hours that they're allowed to be driving.
Because hours of sleep, lack of sleep can affect it. Is that correct?
Yes.
As a matter of fact, there's all kinds of studies say lack of sleep can benefit impairment. Is that correct?
I believe so, yes.
And did you ask Mr. Spitzer how long it had been since he last slept?
I did not.
One of the things that I'm curious about, you indicated that you want them up here, their hands up here so you can see, because otherwise they'd be dragged for a weapon. Is that correct?
Yes.
That doesn't happen in this situation, all right?
You say consider it.
Could not. You pat him down.
Right.
Were you confused as to whether he had a weapon?
I did not feel any weapons, no, when I patted them down.
Okay. So you would agree then, actually complying with the Municipal training, was that okay?
Doesn't mean I didn't miss anything.
Just a point of clarification, on the walk and turn, you got a problem, getting left and right. We see that happen everywhere. See, happen in here. Raise your right hand, left goes up. And you said, well, I had to restart him. You never restarted him because he had never started. Is that correct?
He never started the test, no.
Okay, so it wasn't a restart, it was just a, wait a minute, hold on, let me explain this correctly. Take your right foot, put it down.
Reset him for the test. Yes.
Okay. Did you have him, you had him produce his license, is that correct?
Yes.
Did he have to get it out of his wallet? Do you recall?
I believe it was out of his wallet.
Did you ever see him fumbling for anything?
No.
When you asked him for his driver's license, did he hand you a credit card?
No.
You had that happen when you pulled over impaired individuals?
It has happened, yes.
He didn't give you a library card or anything else. He said, here's my driver's license.
Correct.
Is there anything that you asked him to do as far as divided attention skills, well, other than the field sobriety test here, that he performed incorrectly? Is there any other divided attention skill?
Did you say other than the field sobriety?
Other than the SFSD, we've talked about that.
No. Everything I asked him to do, he did.
Okay. Did you give him any other standardized, or excuse me, any other divided attention skills?
I did not.
You can do that, right? You're trained to do those.
I have the option to, yes.
And did you do that in this case?
No.
You had the option to do that before you went straight to the standardized field sobriety test, is that correct?
Yes.
I've got no further questions.
Thank you, Your Honor. Trooper, you were asked about rollover crash and the potential for that having an influence on horizontal gaze nystagmus. Did you ask him more than one time if he had any kind of head injuries or had any problems because of the crash?
I did, yes.
And did he ever indicate that he was having any kind of problems like that?
He did not, no.
You were asked with respect to the horizontal gaze nystagmus test whether you instructed him to follow for the entire test, and I think your answer was that no. Obviously, from the video, you could tell that you didn't. Did he follow for the entire test?
Yes.
Mr. McCown asked you questions that come from the NHTSA manual, about what you would expect to see as far as behavior and indicators given the amount of alcohol that the person had consumed. So if they had 0.15, you might see vomiting, or you might see this and that and the other thing, based on how much alcohol that they had consumed. And then he indicated that the test score was 0.142.
Correct.
In your experience, are the indicators that a person shows as far as impairment somewhat determined by how often they drink?
Yes.
So a person, given your experience and having seen impaired drivers throughout your career, you might see a person that's 0.2. I'll frame this as a question. Is it likely that you might see a person who was a 0.2 that would actually look less impaired than an inexperienced drinker that was of a lesser score? During the time that you were interacting with Mr. Spitzer, did he tell you that he had a drinking problem?
Prior to the arrest, no.
Well, I think after the arrest, did he?
Yes.
What did he say?
I'll recall the exact words. I believe it was one. I can't recall.
Well, was that while we were in the vehicle with him going to the post?
It was either on the way to the post, yes, or when we were at the post.
5:30, Fort Loop.
Smell the odor of alcohol, flavors coming from it. Yeah. Like everything's around it. And if I did that little eye check, I could already tell based on your eyes, you will.
How long you been a state trooper?
7.5 years. Most days. Some days, there's bad days.
You get days like this?
Honestly, I don't mind. I actually enjoy the more practice. This is the first test I've been at. Test I've had before was way busy. I'm used to handling like 3 or 4 crashes a day. There's always something different every day.
Trooper, in the moments before I stopped the video there, did he ask you a question? How did you know that he was drunk?
He just asked me that question.
Is that what you recall, or was there something else further in here that,
I don't recall.
by the way, it's obviously he's in custody at this point. Were you interrogating him, or were you having a conversation with him?
Just trying to pass time while we got to the post.
And the information he gave you there, did he volunteer that, or did you pry it out?
He volunteered it.
I live with my lady. Yeah, we've been living together since she was 15 years old. Well, she was probably 17. Or at my house. What is it? No, I live on County Road 2, Grizzly Ridge. Well, that's my driver's license, that's where my dad lives. That's just where all my driver's license, but I said down to where I live now, County Road 2. Down there? I moved out when I was, well, matter of fact, they got on the street, I wrecked my truck, and I had my permit. Like I said, we got there when I was 15, and I haven't been out there ever since. 18 now. Anyway, her mom and dad had grandparents that passed away. Her brother lived up there for a while. Her brother moved out, and we kind of took the house over. Got a lot of land out there? No.
Is that a fair and accurate representation of your conversation that you had with him? And where were you headed then at that point?
The Ironton State Patrol Building in Southmore.
That's all I have, Your Honor.
Mr. Campbell.
Did you Mirandize him at any point?
I believe so, and I placed the cuffs on before I put them back.
That's your recollection?
Yes.
Before this conversation took place?
Yes.
No further questions?
That's all we have. That's all we have, Your Honor.
Any
Your Honor,
evidence from the defendant?
no evidence, brief argument,
Okay.
if you'd like. Your Honor, it's our position that the field sobriety test should be suppressed along with the arrest. As to the horizontal gaze nystagmus, he has the trooper acknowledged that at least one of them was not done in compliance with the NHTSA protocols. Additionally, we pleaded optokinetic could be an issue in it. I also showed the, and that's, Your Honor, I can point that out in our motion if the court would like. It's on page 7, midway down. Additionally, the officer is supposed to have suspect position minimizing flashing strobes. As we indicated, as we showed on the monitor, when we indicated the view of the defendant as he was performing the horizontal gaze and nystagmus test, and the trooper acknowledged, yes, you had the strobes from the fire truck there, as well as he could still see the strobes off the back of the trooper's deck. Additionally, it's our belief that on the one-leg stand, that does not comport with a sway under NHTSA regulations or common sense. And as to the walk and turn, there was nothing that was shown at all that has been admitted indicating that he somehow moved during the instructional phase, and other than this allegation that he slightly lifted his boot as to make it easier for him to spin it around, I do not believe complies with appropriate scoring for it. I know the court's indicated it has other issues on probable cause going forward, but we do think that's important as far as the testing aspects of it. So.
All right. Do you want, 5 was never admitted into evidence?
Yes, we want to admit.
Your Honor, I would object saying it was not done contemporaneously with. He went back and, under his own statement, viewed video to assist him in preparing it.
I don't think that matters. Okay, here's the bottom line. What are these tests about? Is there a reason to bring this person in to test them further? If this gentleman was over 21, there's a frame where you can drink and drive a vehicle legally. He's under 21. It's illegal in the state of Ohio to consume alcohol when you're under 21. It's illegal in the state of Ohio to operate a motor vehicle when you're under 21 with basically any alcohol. So the smell of alcohol in this wreck, I think, gives the officer probable cause to bring him in and test him. And then he tests 14. So the motion is denied. I'll set it for trial if there's not going to be a plea. Is there going to be a trial or a plea?
Your Honor, I believe I need an opportunity, obviously, to speak to my client about it. If the court if you're wanting an immediate answer, my position would be, let's set it for a date if you want to get it on the calendar.
Set it for a trial. Is there any time problems?
Your Honor, we'd waive any time problems. And honestly, I've not spoken to him about anything beyond this. So I would ask that we be able to reserve a jury trial if we're going to have one. I'm not suggesting that's what's going to occur, but I think I need to preserve all avenues.
Okay. The scheduler's not cooperating. Set for trial June 3rd.
Judge,
At noon.
Judge, I have a trial in Lawrence County, well, I'm sorry, wait a minute. Well, I've got a trial prep.
Okay,
Technically-
June 3rd at noon. If you want a jury trial, then you'll need to file appropriate paperwork.
I'm on my way to Columbus. Can I have that in by the end of the week to give me an
Sure.
opportunity to?
Whatever the time
notify
frame
you?
under the rules is to get it filed.
So, okay. Thank you, Your Honor.
You're welcome.
State of Ohio recalls Laura Nicola, case number CRB 24286.
Something happens.
They moved.
Okay, I'm going to issue a warrant then for and she has a bond. What did you find out from?
From the Immigration Enforcement Removal Center or Agency, that she is not here legally and that she entered the United States in 2020, and she does have a pending immigration hearing on February 2025.
Okay.
So
I think we
this-
have the address. I'm going to direct the clerk to send a copy of a judgment entry saying she left court and a warrant's being issued for her arrest. So that they'll have that information.
Butch, is that what you sent me?
That is to the immigration court.
To the court?
To the court, yes.
Is that,
That's for the February 2025.
I did not
case.
speak with anybody with ICE or
yeah.
Homeland Security. With DHS.
So it looks like, well, we got a court address on here, the name of a judge, so we should be able to get the information to them to know.
Yes.
That this is.
And it's got a case number on there as well, Judge, and the clerk can call it right up. She's not real forthcoming, but all the information's in that text that I sent to you and Mr. Hill.
And I'll let I'm going to send that to Mr. Sowers too, so he'll have that information.
So according to this notice here that was given to us from Mr. Morford, it looks like the date of the hearing was set on May the 20th, 2021, for a hearing on February 25th, 2025.
That's correct.
That's what we need to start doing, setting cases out for years.
Yeah.
That's typical for those immigration cases.
I've been on one immigration case before, I'll never ever get another one.
We're going to have some big thing happen. And
Judge, was it George Stolte that used to do that?
Regarding murders all over the country, but it's ignored.
It's not going to be.
He left and.
Who's that?
Yeah.
Okay, is that it? We're finished?
No.
No? Okay.
State of Ohio versus Nicholas R. Adams, case number TRD 2014-80 on a recall.
So on this, Laura and Nicole, I need to set a bond forfeiture hearing. So let's make that June 3rd.
What was that case number
This one or the?
Next one.
Okay.
And Judge, you notified Mr. Showers?
Yes. I just
Thank you.
texted him.
Thank you, Judge.
Okay. So you were here before they pulled it and then you left? What happened? You left?
I probably just stepped outside.
He's been here for a while, Your Honor, all day off on. He must have been outside whenever they called his case.
Yeah, because I'd already texted Mr. Sowers that you left and you weren't here. So this is on a sentencing on the driving under suspension. Okay, you've got 2 days of community service to do, and you paid some of your fines. This needs to, his review thing needs to be updated.
Yes, Your Honor.
Do you have a payment today?
Yes, sir.
How much are you paying?
$100.
Okay. So make that payment. When can you get your community service done?
As soon as, I don't know.
Are you working or what's?
Yes, sir.
What's your work schedule?
I work usually evenings, but.
What days a week?
I'm off usually on Wednesdays. I work at Fat Patty's in Ashland.
Well, you can work, you just have to be here 7:30 to 2:30-ish.
Yes, Your Honor.
We'll cover it, so it sounds like you're, and Wednesdays for sure, so you need to get in here and get that done.
Yes, sir.
I'll let Mr. Sowards know that you did show up now, so he won't be out hunting for you.
Yes, sir.
If you don't want him hunting for you, because he will find you. And do you have an explanation for missing on May the 6th?
I was out of town in Western Kentucky. My daughter's been going through I guess, a trial, you could say. She was sexually molested by like a close family friend, and like.
How's your daughter?
She's she just turned 17 now, but we've been fighting this since she's been 13, and it happened when she was 11 and 12.
Yeah, sorry for that.
Thank you. It just finished up.
Conviction or?
Yes, sir. He got 20 years.
Wow, okay. All right, so I'll reinstate your bond, see clerk to make your payment, and your next hearing is June 10th. I'll let Mr. Sowers know that you were here.
Yes, sir. Thank you, sir.
You're welcome. Now we're finished.
Is the jump drive for the video still in the machine? Or?
Probably.
No.
No?
I stuck it in the file.
Okay.
Your Honor, the hospital don't have any available right now, but I have a list to go over with to see if we want to.
Okay. All right. Let's go over one.
Yeah.
Well, I mean, as soon as they file have they filed their brief?